This is a part of the appeal in the matter of DM and home partner.
Yes, Mr. Hussain.
My Lords, thank you very much for sitting early. We have produced a table of references regarding justification as promised. You're going to get a third supplementary bundle which contains material that you asked for yesterday.
Yes, we saw that, thank you, which is all just nuts and bolts stuff.
Nuts and bolts
Well,
stuff.
we're most grateful for that.
A couple of authorities, some authorities as well. Can I just
Okay, just be clear about that. Are they authorities that we're going to be being referred to?
the authorities you asked for?
Ones I asked for, okay.
Yes. And the only reference I need to give you is EM Lebanon.
Yes.
Remember, the EM Lebanon, it's paragraph 46, Lady Hale, supplementary 3 bundle, tab 13, page 318.
Yes, I'm just trying to find the reference in my note. Never mind, I'll make it here. What was the paragraph?
Paragraph 46, page 318. It's not.
Okay, paragraph 46. Okay.
Yep.
And will this?
The jury doesn't have this yet, but it is simply the full rules. I'm sorry she hasn't got it. She ought to have it. I've got electronic copies. I'm sorry, I don't want to take time over this.
No, that's fine. Sorry for Mr. Giovanetti. Do you remember I tiresomely asked for all sorts of details and cross-references from the rules, and that I gather is all this is, plus some authorities.
It is going to be authorities, but I don't have them in front of me. It's a little difficult as I'm going to be making my submissions.
No, I understand, but I don't understand to be authorities about which submissions are being made. I just understand to be authorities that referred to yesterday,
exactly.
And weren't in the bundle.
Yeah, or that you asked for.
Yeah.
Bracking.
I shall try not to get too anxious then.
Don't get too anxious. Well, look, you can hand them up really any time. We won't need them during the hearing. No. Just have them handed up over lunch.
My Lord,
this schedule. We won't spend time going through it now, unless that's what you want to do.
No, I would like to do that because we think it's quite important.
Yes, well then
and I'm going to take ground 3 pretty quickly.
Yes, okay.
Just make very short submissions on ground 3.
Yes.
Essentially by reference to the skeleton.
Yes.
But this is obviously important. The first point, first sentence, the burden of justification is on the respondent. We saw that from Lord Wilson in the Killer case. There's no question I accept of balance of probabilities, proof of facts or anything like that. I accept that. It's evaluative, but the burden of justification remains on the Secretary of State. She's required to show balancing severity, the effects of the differential treatment against the importance of her objective, to the extent that the differential treatment will contribute to its achievement. The former outweighs the latter. That the burden's on her to show that in our submission. We say that there's no evidence.
So where are you reading from?
Do you see the table?
Yes.
Just underneath the trend lines. If you look at the table here, my Lord.
So why are you just giving a straight chance out of the judgment? Not the judgment.
It's not just the judgment, but
it's
just to help.
If your time is short, showing us bits of the judgment which you've already familiar with, it doesn't seem to be sensible.
Yeah, but our submission is that there's no evidence to show that this differential treatment furthers the sole objective of the Secretary of State. And indeed, the idea over 25 years that there's any evidence to support that.
Can we just be clear about this? The point I was making to you yesterday was not so much, it's clear that there is no evidence in one sense. The real question is there evidence going the other way?
There is some. I'm going to come to it.
You're going to come to that. Okay.
With the proviso that it is difficult to prove a negative, of course.
Yes.
So you...
No, keep going.
So item 1, the judgment, evidential position, you've got that. You've also seen at sub 4 of 164, I'm still in item 1, that the judge says that it follows that she's not considered the responses to the Belgian request, nor any other evidence. The reason we highlighted this is because it was the Secretary of State's position that she was going to serve evidence in her summary grounds and then decided not to. We see that from the first item, 164. Item 2, the second judgment, we see that she's never given, the judge fined that she's never given active consideration to changing the rules. It's the judgment as to the likely effect isn't based on evidence. Again, judgment, item 3, second judgment, para 54, no evidence, certainly not provided any evidence in support of her objective. And then the reports, perhaps this is much more interesting for you, extracts from the House of Lords EU Committee 2016. We
is
received.
that admissible?
It is, because in our submission, it is uncontroversial that the committee received no evidence. And the reason it is uncontroversial, or should be uncontroversial, is because there's never been any evidence.
That may be so, but are you not relying on proceedings in Parliament?
I think the case, where the case law ends up, is that you can do so if you're relying on a proceeding in Parliament for a proposition of fact that is uncontroversial.
I think we will need some help on this.
Yes, my lord, Mr Hussain asked me about 10 minutes ago, could I confirm that was uncontroversial? And I said I couldn't do so without instructions, understandably.
No.
And I don't have those instructions, so I'm not in a position to confirm it's uncontroversial.
Okay.
No.
I mean, this was considered in detail in SC, and what it says is that statements made to Parliament, it wasn't a report, can be looked at very carefully to demonstrate whether, as a matter of fact, an issue was discussed in Parliament. But you can't then analyse the quality or look at the reasoning and so on.
And I don't want to do that.
Does it? Was it not further considered in Britsits?
Or is it, am I
Yes, it was. But there, Sir James was relying on proceedings in Parliament qualitatively to show that the best interests duty had been discharged.
Yes.
Mr.
Okay.
Bob Joyce, he was in Britsits.
Liberty, which is the judgment we handed down last week, we had interventions from the Speaker.
Right.
And although in the end we didn't really have to decide most of question of admissibility raised some distraction there. This is, you may well be right, but I think just to assume you're right.
I follow that you need help on that. I'm sorry I haven't given it to you. But can I just skip on then to UNHCR, which I think is important.
Yeah.
So item 5, this is their June 2019 report.
Yeah.
We've given you references in the left-hand column. Second assumption is that children arriving on there are not being sent by their parents or other adult family members in the hope those family members can join them later, placing those children's life at risk. This assumption has been challenged by studies. Data obtained as part of UNHCR's research suggests a complex picture which casts doubt on the accuracy of these assumptions. Interviews with children and stakeholders alike have indicated that overwhelmingly the emphasis at the point of flight in the minds of unaccompanied children is the need to escape violence and persecution and reach a place of safety. And then 3.2, this is page 70.
Yes, I looked at this last night. It's very well presented, but I mean, some questions will certainly have to be raised about the size of the sample. Small. Do you remember what the number was?
I can't. We'll find it. Sorry.
It was in the 20s, I think.
Yes, but
I think. Well,
we'll get that.
Okay.
23. Thank you, Mr. Anderson. And then item 6 is another parliamentary committee, so I'll park that. Item 7 is the Joint Amnesty Refugee Council Save the Children report of January 2020. That's the report that has some fairly harrowing accounts of people who are children missing their parents, their mothers, etc., travelling back, risk of re-trafficking. UK government argues that changing rules would encourage parents to send children on unsafe journeys, secure refugee status. No evidence to support this. Children come to the UK, do so only because of a variety of factors, including language, historical, community ties. None of those interviewed had been aware of the family reunion policies of different countries when they were making their journeys. And then here, I mean, this is probably the clearest we get. Ireland, This is at page 193.
Thank you, yes.
Unlike the UK, Ireland, like the UK, didn't opt in to the directive introduced domestic policy 2016, allowing for children to sponsor family members. Ireland saw no significant change in numbers of child asylum applicants in the 2 years prior to New York, 2 years following its introduction. That's fairly significant, a 4-year period, a country near us. Paragraph 8, ICBI report, inspectors asked for rationale for excluding children from sponsors, from sponsoring.
Sorry, just a point about Ireland. I don't know how migration flows are right. I think nearly all of them come across the border from Northern Ireland, don't they? Because it's not practical to reach Ireland by boat
I would have thought
without
so.
coming to the UK first.
I would have thought. I'm looking across to UNHCR. Yes, I would have thought so.
Anyway, there we are.
But in a sense, that's an observation that supports my contention, because if they're here and they can get to Ireland relatively easily, then you'd expect that to happen. If sponsoring, the ability to sponsor family members is the pool, is the incentive to
Okay, they move on to Ireland
Exactly.
in order to be able to do it. Well, okay, yeah.
Well, you're right next door, and for over a 4-year period, no change. And then the ICBI report, the inspectors asked for the rationale for excluding children from sponsoring. Home Office didn't provide any supporting evidence. Told inspectors ministerial red line. Pending new legislation, the recommendation is clarify the position with supporting evidence. And then Home Office come back and say no. I think on the same day the ICBI responds and he says, I recommended Home Office should clarify the position. Importantly, it should provide supporting evidence. Its clarification simply reiterates its familiar lines, offers no supporting evidence. And then item 10 is Mr Botnick, and this is based on what you looked at, what I just showed you, the document that you've looked at, destination elsewhere, item 5. And then on the right-hand side of the column, you also have a reference to Malone Friends submissions. She'll no doubt make those submissions. So that's UNHCR, and we know, obviously, that they are, everything else being equal, their views ought to be given respect. And then we have items 11 to 15, various people, Refugee Council, Refuage, Kent Law Clinic, Oxfam, Help Refugees, all saying no evidence. These are frontline, on the front line, all saying no evidence based on our years operating. That's Help Refugees. Oxfam, the evidence collected by families together, the coalition partners and others demonstrated through interviews, case studies, no evidence. And then the query from Belgium, you had my submission earlier that this was dealing with...
So which item are we now on?
16.
16, right.
You had my submission yesterday that this is dealing with the EK scenario, it's dealing with the Dublin scenario. So anchor phenomenon is dealing with a separate point. To the extent that Ms Giovanetti relies on this later on today, I'll reserve my comments in more detail for reply. You see what we've said. A strong majority indicated they didn't see large numbers, but it's not on point. What is on point is the UK request, item 17, and there none of the responses, we say, identified an increase in arrivals. So that's a quick trawl through the material, and that's the best we can do.
Well, thank you. Obviously, a lot of work went into that at short notice, and we're most grateful.
Not at all. I'm grateful to Ms Mitchell, Mr Portjoy, as ever, and my solicitors, as ever. Caveat, you asked me to prove a negative. It's difficult to do it. Look at all the studies over all this time. I said yesterday that the Secretary of State had not taken, there was no assessment on both sides, taking into account the factors on both sides of the scales to which the court could defer. And we had an exchange on that. My proposition is supported by what the judge said in his second judgment, para 40.4.A. There is no evidence, 40.4.A, second judgment. where he says there is no evidence as to what, if any, consideration the Secretary of State has given to the evidence relied upon by the claimant in the present case. I mean, that's in context, he's dealing with the evidence of the harrowing impact, very considerable adverse impact on children of this policy. And indeed, the Secretary of State has not challenged that in this court, or said that it was somehow wrong. Her skeleton is equivocal on the point. Indeed, maybe wrong, and maybe, as far as we're aware, there is no acknowledgement of the extremity of the suffering that is visited on these children, either in the evidence. You've only got two statements here. That is Mr. Bulchan's, I've already taken you to that, and Dr. Elimach. Probably, apologies if I pronounced that wrong. Emelech.
Right.
Sorry.
Yeah, okay, yep.
And that's at page 326 of the supplementary bundle. They deal with a different point. They deal with the no red line point. They don't say, faced with a discrimination challenge, this is what we did. We balanced these factors, which is, I think, what one almost invariably gets from a defendant. Witness evidence explaining what they did. Hence my submission. There just was no assessment. If there was, you'd expect witness evidence of it. The duty of candour would require that. Explain to the court, cards up, how you approach these difficult, incommensurable issues. All the evidence is now they just red line. They didn't look at it. And you haven't got any acknowledgement either in of the extremity of the suffering.
You've made
in the pleadings,
up to you, but you know you've only got 10 minutes more.
I know. In the
You've
pleadings
made that
or in
point
the
already.
Sorry, right.
Up to
so
you.
I'm going to skip through now ground three. Those are my submissions on ground three.
Absolutely. I don't want to stop you making a point you want to
No,
make.
that was it. But that is an important point.
No, okay, thank you.
In our submission. So ground three, then, this is rationality. Before the court below, this had three limbs. Firstly, and this is our skeleton, 83 to 101.
Yes, thank you. I reread this last night.
Thank you. I'm going to go for it.
I now remember
yes.
what you meant by two limbs. Thank you.
So the first limb was the decision to introduce the rules in 2000.
And that's not an issue anymore. You're not
No,
going that.
second, you're right, my lord.
Yeah.
Thank you. Second, a failure to actively consider the route for which we contend. For example, after July 2018, when you saw the evidence yesterday about that. And then thirdly, a challenge to the rules themselves. So first point, we don't challenge, but it's important to consider the judge's reasoning because he borrows from it to when he deals with the second two limbs. And we address this in our skeleton paragraph 85, that this is the judge at paragraphs 52 to 56. He says at 52, it wouldn't be irrational to consider that the changes would create an incentive. 53, the question was, would they result in a sufficiently large number of children, which outweighed the other side of the balance? No specialist or technical advice. 54, no evidence. 55, judgment as to the future. 56, ample grounds for persons to disagree, but not irrational. As my lord noted, our skeleton's 85, given the paucity of the evidence around that time as to what was going on around that time, we don't challenge that. But the point is, as I said, he fell into error in transposing his reasoning to limb 2 and limb 3 for slightly different reasons. Limb 2, this is our skeleton at 86. He held that the decisions not to review the rules were amenable to judicial review. We've given the reference, relying on the Johnson case. Of course, it was an extreme case, Universal Credit dealing with the non-banking day salary shift and the irrationality of not putting in place a solution to that. And then he concludes at 67 in the judgment the failure to actively consider in the manner, changing the rules in the manner for which we contend was rational for the reasons I have already given, paragraph 66, though he recognised that our material presented a case, quote unquote, for reconsideration at 67. We take 3 points. Skeleton 91. The first point is, although he was aware of the process nature of this challenge, C 57, 58, 60, he didn't adjust the standard of review that he applied. The standard review is set out at 40.1 to 2, and that is directed to an outcome challenge. It's very clear it's directed to an outcome challenge. But more significantly, whether or not to conduct a review, that question did not involve a judgment as to the future, but rather involved investigating the reliability of that judgment as to the future. So that's the first point. Second point we make in our skeleton 92, that the Secretary of State provided no cogent reasons for refusing to review in the light of the changed evidential landscape. No evidence of resource implications, not enough for my learned friend simply to assert in a skeleton, well, this is all terribly difficult.
But she doesn't have to prove anything. She simply, this is irrationality in public law. She says, I'm a government, I've got a lot of things on my plate, I'm not spending time on this. Why is that irrational? In public law terms.
Because we say that we had identified by that, or there was evidence by that time to show that, I don't want to rehearse what I've already said, the harm that was being created, the paucity of evidence supporting the Secretary of State's view, and the only point I'm making right now is that you don't have evidence about this. And so, but I don't want to rehearse submissions. Okay. And the fundamental point is that the respondent seems to rely on her rationale as the reason for refusing to investigate, as the principal reason for refusing to investigate that rationale, and that can't be right. And then thirdly, less importantly, Judge at 61, he appears to have missed half the picture. He doesn't factor in the lack of evidence as to why it was irrational not to review. We don't press skeleton at 96. Don't press that. And then lastly, in the few minutes I have, the irrationality of the rules themselves. Skeleton 98, the parties agreed that the rules themselves were amenable to challenge. CPR 54.1.2a refers to an enactment. There's lots of cases where the target of the judicial review claim is a legal instrument. You could frame it in different ways.
If the rule said only people whose surnames begin with S will get asylum, you could clearly strike down the rule because it's irrational. You don't have to strike down the decision to make the rule, you can strike down the rule itself. Exactly.
Mansoura Begum, Cruz and Johnston, Simon Brown, lots of cases, yes. And again, the judge dismissed this briefly at 70 for reasons already given, quote unquote. And then we rely on the submissions I've already made under ground 2, accepting that there's a higher threshold here because the burden of justification isn't on the Secretary of State here, and we're contending for an outcome in Lim 3. So I accept all that. But in a way that shows that the issues are different in terms of framing in ground 2. I'm slightly ahead of time for once in my life.
Right, well, I'll occupy it just by...
Yes.
I think it's something we trailed yesterday, but I can't identify that we've quite pinned it down. Can we be clear about remedy, or relief, perhaps I should say, on each of the grounds? I think you did briefly deal with this, but just remind me, what relief do you seek on round 1? I think if you succeed on round 1.
It's declaratory relief.
Sorry?
A declaration.
And when they took the decision, say to the 2018 decision, they failed to have regard to Section 55 because they said they didn't have regard to Section 55.
I missed you, sorry.
A declaration, say it's the 2018 decision, a declaration that when they took the 2018 decision, they failed to have regard to Section 55. presumably on the basis they've said they didn't have regard to Section 55.
Yes.
So they wouldn't have to go back and finish that review by looking at Section 55.
No, they would. Of course they would. If your lordships find that they did exercise a function, then one would expect, without an order of mandamus, because the courts don't, they expect.
Okay, well, we can argue about the form of the rule. I agree. We don't normally
declaratory
order. What in substance do you say should happen if you succeed on round one?
The Secretary of State needs to conduct a Section 55 exercise as regards her the current system.
I mean, it rather depends on what the scope of the decision. I mean, if on Mr Pobjoy's arguments,
Yes.
for example, it would be rather different than if one were simply thinking about the 28 suggested decision. If you take the 2018 suggested decision, you say, well, the Secretary of State should have taken into account Section 55 in making that suggested decision. Well, what follows? I mean, does the Secretary of State have to proceed with the policy review that you say was undertaken, or can the Secretary of State just forget about the policy review?
No, we would say it would follow that given that she's not done it in the last 7 years, that she's now got to do it, given that the system's the same. It's not like the 3 million case where there are not going to be any more elections. So the remedy would be futile. There's no futility here at all. No material change. So if the consequence would be of fixing on post-July 18 that she needs to comply with the law.
But the declaration or the relief that you're seeking is a requirement that the Secretary of State sits down and says there will be Section 55 considerations, there is harm to the children in the UK. Yes. Is that outweighed by the harm to other children, people not yet in the UK?
Yes,
you say that the aim you want is to force the Secretary of State by declaration or whatever method to conduct that mental exercise.
Yes, and confront
the issue.
Confront the issues, exactly.
Weighing the one against the other.
Yes, which she's never done.
Yeah.
And then declaration. Sorry. And then
this may be the discussion you've just been having. My Lord's question, is the relief different if you succeed on the Pobjoy basis?
I think it's not, because of the lack of any material change in the system. If the system was different now, then there would be.
Okay. Mr Pobjoy's submissions are another route of getting a review. It may be, if you were right, there'd have to be regular reviews. But at the moment, since you've never had a review,
exactly,
your submissions really seems to me to be aimed at getting the first one off the ground, if you like.
Yes.
Yes. Sorry.
Okay, that's helpful. Round two.
Declaration.
Well, I think in all cases you'll be asking for a declaration. As you said, we don't normally make mandatory orders. I'm just trying to say, what declaration?
Oh, wait, I'm so sorry. I'm so sorry. A declaration that the failure in the rules to provide for a basis for children to sponsor, refugee children to sponsor their nuclear family members is discriminatory, contrary to Article 8 and 14.
And that's all?
Yes.
What would the practical consequence of that be?
The Secretary of State would then have to consider how she wants to remedy that.
Insofar as it's based on a failure to consider, would you be able to say, I've now considered this and I've come to the same substantive conclusion?
Possibly. I think that's quite a complicated question, actually.
Well, I rather assumed all this had been thought about. I mean, But I couldn't find in the claim form, unless I missed it, any which I'm afraid is a vice that happens
Yeah.
too often in
I
these cases.
hear-
You say all unlawful, but
I
you
hear
don't-
what you're saying.
Anyway, okay.
Sorry.
Right. Well, we'll park that for the moment. We'll park that for the moment. But I think we will at some point need an answer. I'd rather have one now than later, but I don't want to press you. Okay. And then ground 3, logically, well, again, it depends which limb you succeed on. Is this right? If you succeed on irrational not to conduct a review, effectively, it's much like the Section 55 relief.
Except that Section 55 is you've got to conduct a review of the system now, and because it's not on the table, what we want isn't on the table. Where limb 2 of round 3, it forces that option on the table, so it's slightly different.
I understood limb 2 to be it is unlawful to have this rule because it is irrational to have this rule. Limb 1 I understood to be you must consider whether or not it's a good idea to have this.
Are we
just
confused? Limb 2, I mean the first of the 2 limbs that you're now relying on.
Yeah.
And then
Now relying on...
Well, limb 1 has been dropped,
Yeah,
so
limb one's
the
dropped.
remaining 2 are limb 2. I thought limb 2, and
It's Johnson. You didn't consider remedying. You didn't consider reviewing.
No, Johnson. We said that they
Sorry,
put in place
it's Johnson Light. I'm sorry. In the sense
not a very helpful. Just tell me without using labels. What are you saying that we should be declaring on limb 2?
that it was irrational not to actively consider changing the rules in the way we contend, i.e.
Okay, so it does not follow the court would be expressing a view as to what the outcome should be.
It's not an outcome
What
challenge.
about limb 3?
That is an outcome challenge.
Yes, that's what I thought. Okay. So that would effectively be a declaration that a failure to allow for child sponsors to for child refugees to sponsor their families was unlawful because irrational.
Yes. And on ground 2, I'll give you the answer now. Yes, it would be open to the Secretary of State to say, look, here's my justification. Because you'd be finding in ground 2, I'm just reversing.
Yes, okay, I've got it. Thank you.
You've got that.
Thank you. That's very, very helpful. We know, and more to the point, Ms. Giovanetti knows what is being asked for. Sorry.
If we find on limb 3 that it's not irrational not to have a rule, how can it be irrational not actively to consider having a rule when you know that the end result will not be irrational?
Because it's a much higher hurdle. You're looking at you're saying that irrespective of any investigations, you've just got to do this. It's outcome based. The first is
Yes,
process
I understood limb 3 to be that on the basis of the evidence,
Yes. Exactly.
it is irrational not to have a rule
Exactly.
allowing for child refugees to sponsor their
That's right.
families. And it must follow from that, if it's irrational not to have a rule, you're legally required to have such a rule.
Of course.
That's why it's a very that's your most ambitious target.
Ambitious and a maximal case. Yeah, I accept that.
Okay. Well, we better not, subject to points that either my lords want to raise, we better hear from oh no, Mr. Pobjoy wants to speak to us.
Yeah, my lord, can I just rise for 20 seconds?
Sorry, had you said anything else, Mr. Hussain?
No, thank you very much.
Of course. Nothing from my lords. Yes.
Just to be, I just want to be completely fair to my own friend, Mrs. Giovanetti, just in relation to the supplemental bundle, which I appreciate she doesn't have in hard copy yet. Just on my points, just what was added. So I added the 3 cases that are referred to in Bridges, so the Bracken case, the Brown case, and what I've done is I've given the cross-references and sidelines.
Yeah, so that's helpful.
Passages. But I also, we had an exchange about anything helpful on what a continuing duty meant. And I found overnight the Body Human Rights Commission has technical guidance, just some statutory guidance. And there were some helpful passages in that on continuing duty. So I drew it to Ms. Giovanetti's attention this morning.
Yes, I see.
That goes beyond what you asked for. So I just wanted to
Thank you. No, that's very clear. Ms. Knight, now embarrassingly, I haven't introduced Ms. Knight. The clerk hasn't been in today. I have, because I took home your bundle to look at that last night, I've left it behind. Rather than waste time me going to get it,
Yes.
is there a spare copy I can use during your submissions?
We've got an
bear
A5
A5?
copy.
Yes, I can bear A5.
Thank
No,
I'm very well.
Oh, they've been offered.
Mr.
They've been
Rathbone
offered
is
from all
now
sides.
offering-
Well, I'd rather have
Full
A.
size.
I'd rather have A4. So
Thank you very much.
I'm most
Take it
grateful.
personally.
Thank you very much.
In fact, so far as that's only really relevant for the documents. So far as your submissions are concerned, I gather, though I haven't got it in hard copy, that there's an updated version of the.
So what? Well, the updated version was.
It only includes updated in the sense it includes references.
The updated version should be within that hard copy.
Oh, is it? Oh, excellent. Okay.
What was sent last night, my lords, at risk of there being a further deluge of paper, was that we identified that the original submissions that were before the judge in the first hearing, which actually contained the substantive analysis of the material, were not contained within any bundle. So these are the May 2022 submissions, and those were sent in digital copy last night. And with permission, I would like to, at least for the sake of completeness, for the court to
Yeah,
have
we better have those. Yes. Sorry.
and then what I've
Yeah.
also done, because again,
Give her everything.
I
why
didn't
not?
have, yes, but I've done a list of essential readings simply because, again, there wasn't one.
Just while we're doing this housekeeping, why don't we also then have the third bundle? Is that available in court now? This is. I haven't got it. All right. Sorry.
That's what I've just. We don't need this. Oh, and we've also, again, something that was identified yesterday.
Well, hang on. Give everything to the usher in
Yes,
one go.
it is. Sorry, there was just a duplication there. We've given everything to you.
Oh, I see. Right.
Thank you. Apologies. So what my lord I should have then, and what my lord should have is a copy of the 2022 submissions.
I haven't got everything yet, so
Yes, I'll
very
just-
sensibly the usher's collating it.
That's
It would have been more helpful if that had been done
apologies.
beforehand.
Yes.
It's usually helpful to have things
Thank you.
in advance of the hearing so we can read them, Miss Nake. It's less helpful to be handed things at the
My lord,
start.
those submissions that were omitted from the bundle were when we identified that yesterday, unfortunately, were sort of emailed to the court by digital copy. And
Anyway,
And what I've just done, just for the purpose of what might have been a truncated timetable and still may, just identified a key list of documents for those hearings. And I appreciate, my lord, it would have been much more helpful for the court to have those in advance. And the final document, before I start, was just one updating document from my client, which is dated July 2024, which were recommendations made to the UK government, which specifically include the recommendation about expanding the criteria for...
these can only ever be background because
Yes.
the relevant decisions were made.
Indeed. It was for the sake of completeness, just
Okay,
so the court
thank
is
you.
aware that, in fact, the UNHCR, my clients, have been in regular and specific contact with the Secretary of State's Home Department, specifically on this issue, and most recently, aside from what's in the general guidelines of December 2024, which my lord has admitted, was actually in July 2024. So for that purpose and that purpose alone, we seek permission to hand up the
Well,
recommendation.
we won't give you permission or not. We'll just
Yes,
keep
yes.
them divenius.
That's
Yep,
fine.
thank you.
Very much. So, as my lord has noted, the key material for UNHCR that is contained largely within SB2,
Yes.
subject to the submissions that were before the court in the second hearing, which are at SB1 tab 33, and at the most and then the thing that I've just handed up now, which is the first set of submissions. What I would just like to do, of course, as we're clear, the guidelines, the 2024 guidelines, of course, permission was given to adduce those. But what they really do is support the position that was advanced before the court at the very first, which was in relation to why UNHCR's position as to why there should be a direct route for child refugees to sponsor their family members. And given the limited amount of time we have, I thought it would be better to focus, if I may, today, just on what the UNHCR's evidence is, particularly in response to my Lord's question, where we ended yesterday, which Mr Hussain has addressed for his client, as to what is the evidence, if any, about so-called anchor children, to justify the Secretary of State's position. So, if I may just ask the court to turn to the document I've just handed up. It's the 30th of May document, which...
Sorry, what's the 30th of May document?
Sorry, the first set of written submissions. It's the hard copy.
Oh, I see. Yes, no, that's fine.
Set of submissions out that we have
Recognize
there.
it by date. Yep, got it.
And so those submissions, if I just may turn to paragraph 4 first of all, identify that the context, which is the lawfulness of the UK's policy, and at the time those submissions are written, paragraph 4, there were 3,000 unaccompanied children, or 3,112, who were granted refugee status and 148 granted humanitarian protection, but that none of those children were eligible for family reunification. And so that's the context in which we made the submissions. And then at paragraph 5, as you can see, what the headline points were: 1, the submissions in summary to ensure that there was a route, and 2, there must be an effective mechanism. But 3, and that's the part I'm going to focus on in view of the time today, that the defendant's concerns regarding anchor children are without sufficient evidence to justify her policy and impact. And so those submissions, I'm just going to although they start at paragraph 21, I just wanted to just contextualise them by taking the court to paragraph 15, just to remind the court about the harmful effect on refugees, which is part of the context for the submission. And
sorry, that is the paragraphing here. So
paragraph,
which page is paragraph 15 on?
14, my lord. Internal 14. So again, just reinforcing the evidence that the UNHCR have produced, particularly in their report, A Refugee and Them, which was analysing, I think, 65 children's journeys. But importantly...
This was 65 children, was it?
Yes, that was 65. All these reports came in 2019, but the UNHCR report of June 2019, A Refugee and Them, was what was described as a participatory assessment of the reception and early integration of unaccompanied refugee children in the UK. And the key part is over the page at 15. The report demonstrates that there are major barriers to integration for unaccompanied children, but and then it refers back to Mr Botanick's witness statement, which we may turn to if we have time. But this is the key part this is Mr Botanick's first witness statement from April 2022. This is actually paragraphs 28 to 30. The key finding of the report was based on interviews with the participants. There was a lack of contact with and an inability to reunite with family members, which was identified as a major barrier to integration for unaccompanied children, which obviously impacted negatively on their emotional well-being and hindered them from coping in their new surroundings. That finding obviously supports, we submit, that the lack of if there is such lack of contact as that study identifies, then it's not consistent with children being sent as anchor children, for example, which is the Secretary of State's position. Second,
I don't understand that.
Well, the inference we submit is that if children were...
So this is the inference from the first paragraph?
From the first paragraph, which was that if the children were being sent, that there wouldn't be a lack of contact, because, in fact, if the suggestion was that there was supposed to be a strategy, so called by parents, that in fact there would be contact between the parent and child. So one of the
sorry, I'm not understanding. The first paragraph simply says, which, speaking for myself, I have no difficulty understanding, that not being able to contact your parents once you're here and an inability to reunite with them is deeply distressing. And well, of course, that's. But that I wasn't quite clear what other point you were making from that.
Well, I'll move. The point I was simply making was that there wasn't. If the children are not in contact with the parents, then that supports an argument that they're not being sent as anchor children to facilitate family reunion with parents subsequently. But I will move. We have a better position than that. That was merely contextual, and I can take you, my lord, to the main submissions. But just to summarise there, Mr Botanick's evidence at 29, that obviously discussing family was a distressing topic in paragraph 30.
So paragraph 29.
Sorry, the second indented paragraph of the italicised part there in paragraph 15.
One starting for many young people.
Yes, for many
young people. Not being picky, I just want to make sure I'm looking at the same document. Why do you say 29?
It's a direct quote from Mr Botanick's witness statement, which is actually paragraph 29 of his witness
statement. I see, you just left out the paragraph.
And I see that
no, that's fine. No, now I understand.
Yes.
Okay.
Thank you. And then that report concluded, as you can see, that family reunification should be a core part of any national strategy to strengthen the
Where do I see that?
That's the next indented, italicized, yes.
That's paragraph 30.
So just turning over to paragraph 19.
So you're not relying on 29 itself?
My
I'd
lord,
have thought 29 was the one, because he does say, this may be partly explained by children understanding they're not eligible to sponsor their family members under the rules. Isn't that the key point from your point of view?
That is an important part of that quote there.
But what is that based on? I mean, does he know what they understand and what they don't understand about the rules and the distinction between the rules and the guidance?
Mr. Botnick, when we just look at Mr. Botnick's witness evidence in substance in a moment, Mr. Botnick's evidence is that there is no suggestion that children are aware of any from this study, that children are aware of any particular routes, whether it's policy or rule.
Well, that's rather what I thought the flavour was. In which case, I mean, it seems to me inherently rather unlikely that refugee children in this
there's no sophistication about
would have an understanding of the niceties of the rules, of the distinction between a general rule, I mean a default rule such as is in the rules, and a discretionary rule such as was then in the guidance.
Yes. So the case study evidence is that families from the country of origins don't know what the nuance of the laws are.
I mean, I'm slightly bothered. This is all second-hand. This is the witness seeking to draw things from the report. Well, we've got the report.
Yes.
So where in the report are these things said?
My lord, if I could just finish this part, and I'll take my lord then to the report, if I may. If I can just turn over the page to just at paragraph 19 of this submission, which is...
But this is again, paragraph 19 is again about a report. It's up to you, but time is short.
My lord,
Shouldn't we be going to the core documents rather than to the summaries?
I will take the court to the court. I just wanted to take my lord to the submission at paragraph 21. Perhaps I can get there more quickly. But again, just the 2019 Destination Anywhere report identifies
Sorry, 21. You said.
Yes, so that was 19 introduces the report Destination Anywhere, which was the...
Yes, you said you were taking us to paragraph 21.
21 is the submission. The defendant's concerns regarding anchor children are without sufficient evidence. So, in that submission, the UNHCR identified three points. The first, at paragraph 21.1, refers to the House of Lords Committee, which is that there's no evidence to support. I think Mr. Hussein may have taken you to that. 21.2 refers to the case of AT, again, which I think that we looked at yesterday.
Did we?
There's a site. It's certainly cited in the appellant.
Well, we didn't look at it yesterday. I mean, if it's important, we should look at it. But I just
we don't need to go beyond
Okay,
the
right.
reference, other than Mr Justice
Okay.
McCloskey at 21.2, saying that in his in the judgment there was no underlying evidence in the form of reports or commentaries to support the Secretary of State's position as to it being necessary to safeguard children. But the key point from the UNHCR's perspective is summarised at paragraph 22, and I'll then take you to Mr Botnick and then the underlying reports. But Mr Botnick's evidence at paragraph 22 of this submission says that the evidence doesn't support the assumption, this is at the second sentence of that paragraph, that children were sent abroad as an anchor in the hope that other children...
And we knew that's
Yes.
his position.
And the UNHCR's report, Destination Anywhere, explains that defendants' assumption had been challenged by earlier studies and that concluded that the data and information obtained in the course of the research cast further doubt on its accuracy. And in particular, the children interviewed and the other stakeholders reported flight from danger as a key driver of departure. That's page 20 of the report. And
Well, are we going to? Are we going to go to the report?
my lord, I'm happy to.
Well,
go
it's up to you. But all I'm trying to say, both my lord and I,
Yes.
reading submissions is fine. But if time is what you can really help us, because you know what's important in these
Yes.
reports, which is the evidence.
Yes, I'm conscious that we haven't, that my lord hadn't seen this document before. But if I can just turn to the report, which
Yes.
is at SB2,
Yeah.
tab 9. It starts at page 65, and recognising that those references at the bottom are from the old, a further bundle, so the only relevant
Okay, so this is the Destination Anywhere report.
Destination Anywhere.
Yeah, thank you.
And in the introduction, what we see there is that so the summary of what I've just highlighted there comes from the introductory page, which is at page 66
Yeah.
of the bundle. So data in the second paragraph down, data obtained as part of UNHCR's research of this report suggests a complex picture which casts doubt on the accuracy of those assumptions being the anchor child, if I can summarise it in particular. And interviews with children and stakeholders alike have indicated and overwhelmingly that the emphasis at the point of flight in the minds of unaccompanied children is the need to escape violence and persecution and to reach a place of safety. That they provide that the point at which the UK crystallises as the destination of choice differs greatly among the children and young people interviewed for this study, and is heavily influenced by lack of support, safety and information that children experience en route. So the conclusion there on the last paragraph, which identifies that it summarises how they've concluded the research process. And section 4 of the report concludes with a number of recommendations for the UK government as how they can improve the process. So if I can just take the report over to page 67.
Yes.
It sets out what are the research questions, which are in bold 1, 2, 3. What are the circumstances? What are the profile? And what practice and reform?
Yeah, so 1 is the one that's of most relevance to us. Yep.
Looks at the research methods at 2.3. We accept,
Yes, that's where I got the figure
yes,
of
we
23
accept
from.
that it's a small sample size. And the only observation we'd make in relation to that is that, of course, the Secretary of State is very well placed to undertake her own research from the children who are in the UK, who she grants refugee status to, who are in local authority care. And the UNHCR undertook this report and the second and third reports, as Mr Botnick explains in his witness statement, in order to address those concerns of the UK and to try to unpack and unpick them. So that's the sample size, and it recognises, despite at the bottom of the page, this comparatively small primary data set, the triangulation of different qualitative research methods supported the development and verification of the findings arising from the sources. We don't need to look at those next pages, but the if I can take the at 3.2 at the top of page 70, the research findings indicate that children tend not to know where they're going at the point of departure from their country of origin. Children and stakeholders alike indicated that the decision to leave is often chaotic and disorientating for the child, who may lack knowledge about where their next or final destination will be, despite the fact that some children have a clear intention of wanting to reach the UK or indeed another EU country from the outset. This wasn't evident from those interviewed for this study. Overwhelmingly, they reported their imminent concern, was to escape danger and to reach a place of safety without a specific destination in mind. And this finding was supported by evidence.
Sorry, if you're ready to read long chunks, it's much
Yes,
better to
okay.
ask us what you want us to read.
Yes.
I did in fact read this last night, but what are the, how much do you want us to read? Of
So
this?
if you just read the that finding was supported by the
Yeah.
first sentence there from the stakeholders UK, France and Greece. I just wanted to just take the court to three other passages in this report and then to the recommendations. At 71, over the page, in the middle part of that passage on the left, one reason the court could read that passage.
Sorry, page 71.
Page 71. It's
Other, one reason children may lack
Yeah.
knowledge. Yep, okay. Yes.
Just one thought that strikes me is the people you should be asking are the parents, not the children, isn't it? Because they're children, they wouldn't necessarily be involved, as this says.
Well, my lord, there was stakeholder interview, which I referred back to at paragraph 2.3 of the report we're on, which was that the interviews with children, young people, as well as key expert interviews and a range of stakeholders, which are described at 2.4, including the frontline NGOs and so on, include children's services, paediatricians, psychologists, legal professionals, foster carers, and so on. So it isn't just information coming from the children; it is supported by those professionals who support the children.
Yes, and it's all from the children. What we are worried about is what are the parents doing?
Well, my lord, I'm grateful to my learned friend Mr Saint for just reminding me and the court that it isn't just information from the children, because it does directly, the research process directly includes a range of professionals who are there to support children. That's at paragraph 68, page 68, the second paragraph. So we would submit very strongly that all of those interviews support what the children say, and the account that the UNHCR's analysis, without it just being directly from those children. When parents are reunited with their families, no doubt that's when such interviews could take place, and the Secretary of State hasn't, is well placed to do that. But the UNHCR's position is, as Mr Botnick says in his witness statement, in order to try, this is at paragraph, I haven't taken you there, because of shortage of time we may not have the time, but in his witness statement, which on that list of essential reading, he addresses why the UNHCR went to look at all these, to create these three studies, in particular to address why was the UK an outlier along with, I think, Switzerland and Liechtenstein within Europe, and particularly to look at what was the experience of those children. So that's Mr Botnick's witness evidence, which is at paragraph 20 of his witness statement, 21, which we may not get to, says the UNHCR specifically commissioned this to try to understand and interrogate the UK's position. So that's why those recommendations.
No, I'm sure,
highlighted.
but it's nevertheless very helpful to be taken through the study. Why it was created is secondary.
Yes. If I could just then take the court to one more passage in this report, which is at 3.3.3, page 72. Which is that the influence and location of the family. Important. This is perhaps the court could just read that part without me reading.
How much? The whole of 3.3.3.
Just
Those three paragraphs.
Yes. Well, the first. Yes, 3 paragraphs would be helpful. Yeah.
Okay. Thank you. Just one factual question.
Yeah.
UNHCR refers to the common concern of EU member states, i.e. not just a UK concern.
Yes.
Do we know, is there anywhere in this report which shows where that concern is expressed by perhaps not all UK members, EU member states, but obviously by many of them?
Not in this report. In the report called Families Together, which is behind tab 11, the UNHCR do recognise that some member states there do not apply the broader definition. That's the UK, Switzerland, Liechtenstein, as I mentioned. And the recommendation that the UNHCR make there at 103. So if I can just.
This is 103 of the bundle. Of our bundle.
Yeah,
yes,
behind tab 11.
Yes, I see the recommendation. I was just interested. I mean, this is being presented, I quite understand it here, I'm not saying anything wrong, as the UK taking a position, and part of their rules they do take a different position from other member states.
Yes.
But it does appear that that doesn't mean that other member states don't share the same concerns. Indeed, we know Belgium did, because that's what started the Belgian,
yes, indeed.
The Belgian query. And I just wondered what evidence we had about the attitudes of other member states. It will only be in these documents.
The only thing we have in this document that might assist us at 101, which talks about difficulties accessing family reunification, which starts at the top. Despite many persons being legally entitled to bring their families, they face practical difficulties. But aside from the member states who restrict, which is the UK, Liechtenstein and Switzerland, there isn't any. I don't think I can see anything in this.
No, I think this is a fair summary, so I read this as well. That there's this specific and important concern about UK, but there are other concerns about the EU, many EU member states adopting what you might call grudging approaches to family reunification, such as only allowing nuclear family and so on. And
well, one of the specific.
But I haven't detected any particular concern about what you might call the use of anchor children.
No, this report.
But that is elusively referred to in the previous report.
If that's what it really means, I'll just
confirm
that with my client. But for example, one of the considerations at page 102 of the Families Together report was that unaccompanied children not being able to bring their siblings over 18. So it was that kind of expansive family reunification model that the UNHCR was recommending at the page 103. They should expand the scope of family reunification by consistently applying a broader definition of family, prioritising dependency as the primary criteria, including for
Yes, you're slipping away from the point I'm asking you, which is concerns about the deliberate use of anchor children.
Yes,
And I haven't seen
I don't
that
think you'll
expressed
find
anywhere.
anything in this report.
Yeah, okay,
that
thank you.
addresses that.
I'm just puzzled about one thing, because we are a court of law, and I understand the recommendation. I thought it was said as a matter of law on a different basis that a child not being able to bring his parents
Yes.
and his siblings under 18. But are you saying it's a matter of law, or are you saying UNHCR would prefer if others could also come, siblings over 18?
Yes, well, the UNHCR doesn't limit the question of who the child should be able to sponsor in terms of other siblings, but where those other siblings are over 18, how that rule is drawn may it's not a matter for the UNHCR, but the recommendation.
The UNHCR's position seems to be, just reading what you've shown us, that they would wish member states to allow siblings over 18.
Yes, where they form part of the nuclear family, and where there's evidence of dependency, and that's what the recommendation from Families Together is.
Well, look, we've got enough on our plate, considering the particular problem of the UK's policy, without looking at other member states' policy. I was only interested in it on this question of a supposed common concern about other EU member states, and you've shown us what there is.
Yes,
so let's go back to where you were.
Yes. So in short, we say that the other member states, there's nothing in there, the documents that show a concern in relation to the UK concern of anchor children, or the claim of anchor children, and that's what leads to the very clear recommendation in this report at page 74, this being the original Destination Anywhere report, which is to allow unaccompanied children to have a family reunion. The Refugee and Then report, which is a recommendation very clearly based on the evidence as to the impact on the children of that separation, which is at 93. And then the final...
sorry, I thought Refugee and Then started at 80. Oh, you mean
yes,
the particular passage?
Yes, it starts at 80, and the recommendation is at 93.
Oh, I see, yes.
Yes. But the importance of a Refugee and Then was that evidence of the 65 children was particularly to focus on the impact on them of not having a route to sponsor their families and not having and being separated from them as a result, and hence the recommendation that was reinforced at page 93 of the report. So
the recommendation here, unless I've missed it, it's that refugee children be allowed to sponsor their parents or guardians.
Yes, that's
not siblings.
In this report, yes, but it's not limited to that. The reports all go to possibly slightly different issues, but the first recommendation in Destination Anywhere was to specifically at page 76 amend the rules to enable unaccompanied refugee children to sponsor their parents, guardians, and siblings to join them in the UK. There's no doubt about that. And then the third recommendation.
Hold on, so I'm at 76.
76, my lord.
Yeah.
And the third recommendation in Families Together was the broader, the point in relation to broader EU, expand the scope to focus on the UNHCR position, which is about family unity being about a core principle, and where there is dependency of those other family members on the family unit, then those children, those family members should be able to apply to come. So that's that was what the UNHCR position. That was the evidence that they had commissioned or sought to investigate. I just wanted to take you to Mr Botnick's witness statement, if I may, just very briefly, which is at tab 8 of Supplementary Bundle 2.
Is this the last thing you're going to be doing? Because
Yes, I appreciate.
I'm concerned we really do need to be.
Yes, indeed. I just wanted to take you to that witness statement.
Yes.
Paragraph 20. It's page 57. Just importantly, I said that point, but this is the evidence. The UNHCR, why they conducted the research.
So where are you reading from?
Paragraph 57, page 57, paragraph 20.
Yes.
Of Mr Botnick's first witness statement, which is that they conducted.
No, I've got it.
Yeah. So that's the point. That's the point. And paragraph 21, the purpose of the research paper.
But this section surely is just a summary of the reports you've helpfully taken us to.
Yes.
So what do we get from this that we don't get from there?
Just the summary. Apart from the summaries of the reports I've taken you to, but the purpose of the witness statement is to show why UNHCR thought it was important to commission the research. That's really what it comes down to.
In a sense, obviously we have huge respect for UNHCR. I don't mean this rudely, but we don't need to know why. The fact is they did. Yeah.
My lord. And there's just there to take you to the conclusion of that witness statement. Page 63, paragraphs 35 and 36. 36, importantly, says in UNHCR's view, the very final sentence of 36, there's no clear evidence to support the UK government's position, and our research details the complex factors that influence children's journeys to the UK.
Yes.
That's the UNHCR institutional view.
Yes.
As then in 2019 and now, as most recently recommended to the government in their recommendations of
But
July.
just to be clear about this, and I think the judge said the same thing.
Yes.
Of course, that's the UNHCR's institutional view, which deserves great respect. But the respondent's case has the defendant's case, appellant's case, let's start again, that you're supporting, has to be that ought also to be the view of the UK government, and that's something that, insofar as it's a matter for us to decide at all, we can only do by reference to the underlying evidence, and that's why it's so helpful that you've taken us to those reports, and that's where.
Yes, my lord, and the Secretary of State sets her position out in her response to our intervention.
Yes.
She says she accepts the importance of our role, and she accepts.
Well, I've seen all that.
Yes, all of that, and then she just simply says we're not obliged to accept the recommendations with which they don't agree.
Yes.
But they haven't. There's no analysis or response to that evidence, and that's, I think, our.
So your submission is Secretary of State disagrees but doesn't say why.
Yes. And I think that's important in light of not only the 2019 reports, but what has been happening since then in 2024 in particular. And one final point, we don't need to labour the court with, but the Secretary of State says that she doesn't quite understand the UNHCR's position. That's at 7 to 9 of that response. And
Yeah.
our position is that there should be a right of access promoted through a rule. That's the key point, if I can put it into a sentence. And you'll find our submissions are more.
Yeah, well, there is a rule now, but your point is that the rule should surely. I thought your point is the same as the appellants, that the rule should be one which
allows
basically doesn't have any hurdles about exceptional or compassionate circumstances. It's just a straightforward rule rather than one providing the exercise of a discretion.
Yes, must permit the child to act as the sponsor.
Yeah. Okay, well, that's very helpful.
Thank you very much.
Thank you very much, Ms. Knight. Yes, Mr. Giovanetti.
Thank you, my lord.
Well, I think we are, thanks to Ms. Knight's economy, we're on track.
I think we are, and I shall do our best, my best, to keep us that way. So, we're dividing submissions between us, Mr. Anderson and I, slightly differently. I'm going to deal with ground one, and that's both limbs of ground one. Mr. Hussein's rather more straightforward, the ground that was advanced below the failure to have regard to section 55 in making a decision not to review the rules. But I'll also move on to deal with Mr Pobjoy's continuing obligation analysis, the second limb. Mr Anderson will then deal with discrimination. In the course of that, he'll be addressing justification, which I think will probably encompass most of the rationality points, but I'll sweep up any that are left and aim to be finished on time.
Sorry, yeah. So you're saying that insofar as there's anything left of round 3, you'll deal with that?
Yes.
Yeah, okay. Yeah. So what, you're going to be...
I'll be focusing.
You'll be sitting down, then he'll be dealing with round 2, and then you'll get up again. I don't mind. That's one. You're not going to deal with round 3 first time round.
I'm not going to deal with round 3
Okay.
first time round. And it may well be I don't need to get up again at all.
No, I take there's obviously a considerable overlap, but they are not identical.
They're not identical.
No.
So could I, before addressing both bases on which round 1 the section 55 is put, just start off by looking again briefly at section 55 and what it requires. We've got it in a couple of places, but I think we listed it before at tab 1 of the first volume of the authority bundle. So I'll go back to that.
Just one moment. Yeah.
There was some discussion in the course of Mr Hussein's submissions about the opening words of section 55(1.
Yes.
The Secretary of State must make arrangements for ensuring that the functions, etc. What's meant by making arrangements? And that needs to be read together with section 55(3, which is a provision for statutory guidance and imposes a duty on a person exercising any of the functions in 55(2) to have regard to any guidance given to the person by the Secretary of State for the purposes of subsection 1.
Yes, so there's no obligation as such on the Secretary of State to give guidance. If he or she does, then they must have regard to it.
Yes.
Yep, okay.
But in fact, guidance was given. There was statutory guidance. And I don't know if you've got the third bundle because we asked for this to be included. And I've seen the electronic index, so I know it is there. I won't take you to it, but it's quite hefty. It was issued in 2009, I think.
So this isn't the bundle which we haven't yet had.
And
hard
I
copy.
don't
No, I don't
have
mind.
it.
I just want to make sure which bundle you mean. We'll call that supplementary 3.
Supplementary 3.
Yes, I see.
It's the Every Child Matters guidance. And it's quite comprehensive. But in addition to that, the Secretary of State has issued specific guidance.
Sorry, as we haven't got it. Does Every Child Matters, it's not only concerned with, it's only concerned with functions relating to immigration, asylum or nationality?
It goes slightly wider because part of the purpose, you'll see when you get a chance to look at it, but part of the purpose of section 55 was it was, I think, in the light of the Laming report, to ensure that relevant bodies were working together.
Yes,
so it's got a lot in it about communication, information sharing, working with local authorities.
Yes, I see. Okay.
Who have issued parallel guidance, and they're intended to be seen as a framework for the protection of children.
That's very helpful. But still, the focus is on immigration.
It is.
Presumably,
yes.
Customs isn't quite so important.
No.
Right. Sorry, I distracted you. You were about to say, in addition to Every Child Matters, there is ...
Yes. The Secretary of State has repeatedly issued guidance specific to the discharge of particular areas of activity.
Yeah.
And since Section 55 came into force, every iteration of the guidance on family reunion applications applications involving a child has required decision makers to consider the best interest of the child as a primary consideration. And you see that from the supplementary bundle at page 327, back to the witness statement of Ms. Elimelech.
Sorry, that was the first supplementary bundle.
The first supplementary bundle.
And I wasn't paying sufficient attention to which one.
The witness statement
327.
starts at 326. And she deals with the guidance in this regard at paragraphs 9 and 10.
But can we just be clear about this? That's obviously right, but what the judge said, and obviously what Mr. Hussain says is, that's all very well. The guidance refers to individual decisions, but they are individual decisions taken within the framework of the rules. And it's a bit of a red herring because his target is that the rules provide for inferior rights for children.
My Lord's one step ahead of me. I was moving to that.
Oh, sorry.
But in my submission, no.
Sorry.
No, absolutely
I
not.
trust you,
It's
Mr.
really
Justice.
important to have this as the general background because it's easy to forget that what we're looking at here is how individual decisions are made, and in each individual decision to grant or refuse entry clearance to the family members of a child, the decision maker has been required, because the Secretary of State has been making arrangements in accordance with the Section 55 obligation, to have regard to best interests.
I'm not sure that I quite agree with that. I'm so sorry.
No, not at all.
It is important to look at the wording of 55.
Yeah.
And the two things that strike one about 55.1 is make arrangements and the functions are discharged.
Yes.
You look at 3 and that's actually talking about exercising functions.
Yes.
So it seems to me that 55.1 might be talking about you must make arrangements as to how you're going to go about discharging those functions that are given to you. And a number of functions are given to the Secretary of State. They include, from time to time, laying statements of practice. So they must make arrangements about that. That may introduce Mr. Pobjoy's second argument that the arrangement must include arrangements about regular review. So the making arrangements about how you would discharge your functions is different from I've actually done something on a particular occasion.
That's a very interesting point.
Oh, sorry.
I'll reflect on it.
Right.
And when I come to deal with Mr. Pobjoy's continuing point, maybe I can address it at
Yeah,
that
okay.
point.
It's just that follows on really, I think, from what Mr. He's nodding. That's what I thought he was doing. Yeah.
But for present purposes,
Sorry, just before we leave this, I'm not sure this is necessarily quite the same point as my lord's. I still find the structure of one as slightly odd. Why it's structured in terms of must make arrangements for. My lord has suggested one possible reason. Is there no authority in which this slightly odd formulation has been reviewed?
not one I think that either of the parties
No.
are aware of, or indeed UNHCR. I mean, we
Well,
can certainly do
then
some
I'm
more
sure there
work,
isn't.
and if we come across anything, we will try and maybe put in an agreed note if there's any authority that does address it. But you'll have seen that the research is between everybody have been quite comprehensive.
Absolutely. Absolutely.
Not
but the
impossible
trouble
to
is,
miss something.
the statutory draftsmen use these formulas and they usually have a reason. And authority is the obvious place to find it. There might be something in explanatory. I don't know. All I'm saying is it puzzles me.
The wording is very different from 149.
Yes, it is. Oh, definitely. Yeah. It's one of my points that I'm going to come to in due course.
Right.
They are quite different duties. What I just thought was that I might have a look. I can't remember actually looking at the language of Section 11.2 of the Children Act 2004, yes, which is the one that imposes that duty to have regard. It may be that Mr Anderson can help with that over lunchtime, but that might also be a make arrangements duty because it's a similar sort of.
Any help you can give would be useful.
And the last point on this is another reason why it may be discharging functions is you're talking about the immigration thing. The Secretary of State has got to keep her eye on the individual officers who are taking decisions.
Yes.
She's also got to keep her eye on her own functions because she's got bigger functions.
Yes.
So the arrangements to discharge functions could be ensuring, one, that there's guidance to the officers, don't forget children and their importance, but two, she's got to, when she's discharging her functions, for example, under 3.2, herself to remember that if it's relevant, she's got to have regard to the interests of the children.
I think it does tie into the Mr Pobjoy's second continuing obligation point, because you'll see when I get to it that in my submission, whilst it's plain that making an immigration rule, section of immigration rules, or amending them is a function, there are a lot of preliminary steps to that. So the Secretary of State will decide what her policy imperatives are at any particular time, and then may be influenced by current affairs or by other considerations, problems that are arising in the system, and she decides which rules she's going to review or amend, and that's not the exercise of a function, that's a preliminary stage, but I'll get to that in due course.
It may be a preliminary stage, it may not be the exercise of the function, maybe the discharge of the function.
Well, let's come back to that at the next stage.
Very interesting.
So just to nail down one point, I understood your submission before we started asking you questions was that subsection 3 is at least the contemplated guidance in subsection 3 is one of the arrangements under subsection 1, but it's not likely to be exhaustive because otherwise you could just have a conventional the Secretary of State must give guidance provision at the time we've seen in lots of statutes.
Yes. I mean, that is the key way in which she exercises or makes her arrangements.
Okay.
But it can involve other things as well. So I think one of the examples that's referred to, I think it's in the Every Child Matters, is arranging training, for example, for officials. And just before we leave it, it's not significant for our purposes, but there was some discussion when Mr Hussain was making his submissions about 55(2) A and B, Secretary of State and Immigration Officers. I think that's because I haven't brought it along, but I expect them to be fairly familiar with it. Section 4 of the Immigration Act 1971 divides the functions, so leave to enter is a function of the immigration officer, leave to remain a function of the Secretary of State.
Yes.
So it's, effectively, as Mr Hussain said, under the Carltona principle, her officials are acting on behalf of the Secretary of State anyway.
Sorry, we detained you longer on that than you intended. You said you were going to make 2 points, I think, but have you made them both?
I think I said I was going to deal with the two limbs separately.
Oh, right.
I think those were the points I wanted to make about.
No, that's very helpful.
55.
Thank you.
Just that the broad guidance has been issued, and that guidance is issued in particular areas. And you've got the guidance that's been issued in this area. We've been to it already. It's in volume 3 of the authorities bundle. It's just worth turning it up, I think. in fact, I think this is the current guidance, so that's probably just as helpful. Yes. So this is the 9th of April 2025 guidance. I think
Sorry, which tab?
49.
Sorry,
I think it's
tab
48.
49.
Yep, thank you. Yep.
And you will see under the heading applications in respect of children,
Which page?
sorry, page 8 of 38, 1900.
Yep.
The current section 55 guidance. And it's not simply a reference to section 55. The first paragraph under that heading summarises section 55. Second one deals with the approach to children overseas. And the third one specifically tells decision makers how they have got to carefully consider. I won't read it out, but I'd ask you to read it. And then there are
Yes.
links at the bottom to other areas of guidance, the first of which is the Every Child Matters statutory guidance.
Yep.
So just to summarise, it's been common ground throughout these proceedings and it's well established. We've got it in MM Lebanon, which is the classic authority, volume 1 of the authorities bundle, tab 13. And just for your reference, page 493, paragraph 46. But the discharge of a function for the purpose of section 55 includes both individual decisions and the making of immigration rules and giving guidance to officials. And the first limb of ground 1, which is the limb that was advanced below, is focused on the second of those two functions, the function of making immigration rules. And the appellant's case was initially put on the basis that the breach was in establishing and maintaining a position. You see that in the core bundle. Page 354.
Sorry, I was thumping my bundles about what was the precise reference?
It's core bundle, page 354.
Yep. Which bit?
I'm not quite there myself yet. Paragraph 94.
So this is the statement of facts and grounds.
Yes.
If it's 354, it can't be para 94. If it's para 94, core bundle, para 94 of the amended statement of facts and grounds is on page 356, starting in summary section 55. Is that right?
Ah, Right, my core bundle is slightly differently paginated, which I will try and take into account.
Oh, that's
as we
very
go
annoying
through.
when that happens. Well, we'll just have to cope.
Yes.
So,
But if you turn to your
I hope
356...
without, I don't want to tear anyone off a strip, if the person who prepared the bundles is in court, can they learn a lesson? Yeah. Okay, 94.
The fault may be mine, my lord. There were various replacement bundles sent out at different times.
I know it can be
I'm not
confusing.
sure which one I ended up marking up. So
I'm not. No need to investigate it. If one doesn't make a slight fuss each time this happens, standards never rise. But I'm not going to make a big fuss. Okay, we have para 94.
Yes, and that was put on the basis of formulating and maintaining her position in relation to family reunion for refugee children. But the appellant's case evolved as summarised by the judge at paragraph 103 of the first judgment. I say tentatively that I have that at 150 of the core bundles.
Be there or thereabouts. Anyway, the paragraph's what matters. Which you say para?
Paragraph 103.
It's 152 for what it's worth. Yep.
In fact, if you pick it up at the bottom of the previous page, you'll see he refers there to the declaration in the claim form in establishing and maintaining a position. And then at 103, 3 points emerged during the course of the hearing. Picking up 3 lines down. As I've already noted, Mr Hussain acknowledged that the Secretary of State could not have used an amendment to the family reunion guidance or anything else short of a change to the immigration rules to introduce the change which the claimant contends. And that is because, as we all know, and I'm not going to take it to you, Mr Hussain's referred to it in the court's plainly familiar, following Alvey, criteria need to be in the rules, how to exercise discretion can be the subject of guidance. But there's another respect in which the way the declaration sought is formulated is relevant. And that's because what was sought was put on in terms of, could you pick it up at little 2?
In para 103.
Para 102, I'm sorry, I'm looking at the form of the declaration.
Yes, I think I was obviously unfair to Mr Hussain, saying I'd forgotten that the declaration then sought, at any rate, was in the claim.
Yeah.
Yep.
So it's the position that's referred to is a position whereby parents and siblings of refugee children are not entitled to family reunion under the immigration rules on the same basis as the spouses and children of adult refugees under the immigration rules. And that's what the complaint's directed at. But in reality, the suggestion that all that would be required would be for parents and siblings of child refugees to be considered on the same basis as the spouses of children of refugees, although it has persisted, is a significant oversimplification of the position, and it's important. The reason it matters is that it's relevant to identifying in this context what is and is not a function for the purposes of Section 55. And that's because, in reality...
Hang on 1 second. Yes, sorry, do go on.
In reality, what would be required would be the formulation of an entirely new and specific set of criteria designed for the situation where the child is the sponsor in the UK and the people seeking entry clearance are the other family members. And can I just take you to the existing immigration rules to demonstrate that? The new ones, as we know, cross-refer to other appendices, so it's not so easy to read across.
So we're looking at the old rules then.
We're looking at the rules
For
in
convenience.
force at the time.
No problem. Remind me where we find those.
You find those at Authorities Volume 3, tab 42. I'm hoping our pagination is the same for this bundle. I have it at 1765, as I'm told.
Well, for what it's worth, in my bundle it's 1764 is the start.
They start at 1764.
Oh right, well then we're in the same place. Yep.
The bit I wanted you to look at is 1765.
Yes.
Now, there are some minor changes in the new rules. One of which is to a bit that I'm going to ask you to look at. It's not particularly material for our purposes. Family reunion requirements for leave to enter or remain as the partner of a refugee, 352A.
Yep.
So one, you could just substitute. The applicant is the parent of the person who currently has refugee status.
One second. So, how many so? Oh, I see. 352A1.
Yes. But the rest of them, if you look at 2 and 3 and 4, they're all focused on a relationship between partners. Those are what the criteria are looking at: the closeness of the relationship, how established is the relationship, how genuine is the relationship. And then at 5, little 5 on the next page, each of the parties intends to live permanently with the other as their partner, and the relationship is genuine and subsisting. But these are not designed, they're not geared towards, they're not directed at the position of the parent or sibling of a child refugee.
So is your point that they can't be on the same basis in the sense there's got to be variation? Is that your point?
Yes, the Secretary of State would have to address her mind to and design criteria that, and I'll come to this a bit more in a moment, that were relevant for the situation we're concerned with.
But isn't it going to be easier for parents? You just have 352A1, because that's the end of the matter with parents. It's more variable with partners.
Well,
you break up with your wife.
My Lord says that, but can I address that in a moment? Because I wouldn't necessarily accept that's the case. So 352D, requirements for leave to enter or remain as the child of a refugee. So that's the situation that was being posited in the context of the discussion about discrimination. Well, the mother, she would say, could just bring the appellant in. Why can't he just bring her in? So again, little 1 can easily be transposed. 2 is under the age of 18.
That's not relevant.
Isn't any longer and not relevant because he was at the time of the application, and one can easily deal with that as well. The child sponsor was under the age of 18 at the date the application was made. But 3 is not leading an independent life, is unmarried, is not a civil partner, and hasn't formed an independent family unit. That's the criterion that has to be satisfied by a child trying to come to the UK. It's harder to measure when you're looking at the position of a child refugee should there be some sort of reverse criterion? That's quite that would be a policy matter for the Secretary of State to determine. There is a substantial difference, for example, between, let's say, a 10-year-old, a young child, who until a few weeks ago was living in the parental home as part of the nuclear family and has come to the UK under the care of a relative, a family friend, and claimed asylum when they got here. And somebody who is just short of their 18th birthday, who may have been living independently and working even before they left the country of refuge. Young people do work at the age of 16, large parts of the world, it's not unknown here, who may have started a relationship in the United Kingdom, may have no intention of living with the parent. Now, I'm not saying that they should be excluded, I'm saying these are matters the Secretary of State would have to address her mind to. At the moment, the cases where child refugees in the UK want to sponsor a family member, they're all looked at on a case-by-case basis. So regard has to be given to the best interests of that child in every case. But the weight and the circumstances will vary from case to case. So what you've got at the moment is a case-by-case individualised approach. That's not to say it's the only way of doing it, but it's not as straightforward as it might have at first appeared to simply substitute the words parent and child. It would be a complex and quite difficult process, I think, for the Secretary of State to balance out precisely what criteria to apply. And I'm sure it wouldn't be uncontroversial.
It's not only to decide what criteria to apply, but also to what extent to have fixed rules,
Yes.
and to what extent to have discretionary considerations.
Yes.
Or quasi-discretionary considerations. For example, one important question might be the extent to which the child was or would be dependent on the parent if the parent came here.
Yes.
And dependency, as we all know, is a multifactorial concept.
Now,
I see.
we accept that if you had a situation like in the Badmus case, where the Secretary of State has commissioned work to be done on something, and said, I'd like to have some policy options identified, and I'm going to choose between them. One of the policy options might well be status quo, do nothing. Others might be alternative versions of the criteria you would have in the rules.
Hang on one second.
Sorry if I'm going too fast.
Sorry, yes, so we accept, you're accepting, if the Secretary of State has in Badmus commissioned a set of options, one of which is do nothing.
Yeah, and others are
I've just-
alternative sets of criteria.
Okay, in such a case, what are you submitting? Or what are you
I'm
accepting?
I suppose, that the Section 55 obligation would bite.
Because she's
What?
exercising her functions as well as discharging them.
Exactly, yes.
But what would bite at the moment of choosing between those
It would bite
options?
to the process of choosing, because we'll look at in a moment at what Section 55 requires a decision maker to do. But in exercising or discharging that function of considering those options and deciding which ones to adopt, she would be required to go through the Section 55 exercise, if I can call it that. And that would be the case even if her ultimate decision was maintain the status quo. And
So the function, sorry, I didn't get your exact words down, but is this a fair summary? The function would be considering the choice between those options.
it would be making a decision as between those options. Yeah, so yes, sorry,
Well, yes, the way you've set it up, it's the same thing, because even if the decision was to do nothing, that would be choosing one of the options.
exactly, yes.
it bluntly, she's deciding what should be in the rules. It may be it'll be the same thing that's already there, but she's applying her mind to what's in the rules. And the task of applying your mind to what is in the rules is certainly exercising and maybe discharging the function.
Yes. So I hope to some degree that sort of squares the circle. For our purposes, in this case, it may not be the same in every case. Could we, just to help with this sort of exercise, look at the project for the registration of children as British citizens case? I think we looked at it briefly before, but not for my purposes. It's in volume 2 of the Authoritative Bundle, at tab 26.
Which tab did you say?
26, my lord.
Yep.
And it's paragraph 70. I'd ask you to look at.
What's the case about? What is happening here?
This one was about charging fees for children to be registered as British citizens. It's not particularly sort of the facts are not important for my purposes, but if you turn over, well, none of this is controversial, can I just say. You pick it up just above letter G on page 1114. Don't need to look at the summary of what section 55 does. 2, the duties imposed on the Secretary of State, she is bound by it, save to the extent, if any, that primary legislation qualifies it, not referred to any qualifying legislation. I'm not suggesting there is any here. The duty applies not only to the making of decisions in individual cases, but also to the function of making subordinate legislation and rules, such as the immigration rules, and giving guidance. In fact, they're subject to affirmative vote. Ours aren't, of course, the immigration rules, but the rules there were. The best interests of the child are a primary consideration, not the primary consideration, still less the paramount consideration or a trump card. This does, however, mean that no other consideration is inherently more significant than the best interest of the child.
These are all taken straight out of Zumbas and cases like that. Yep.
Question to be addressed: if the best interest and point to one conclusion is whether the force of other considerations outweigh. This in turn, and this is what's important, means that the Secretary of State must identify and consider the best interests of the child, or in a case such as the present of children more generally, and must weigh those interests against countervailing considerations. But if you've got a series of policy options, you can meaningfully do that.
But this was started off paragraph 70 for present purposes, and that's why I asked what was going on.
I see.
And the problem here, presumably, although you haven't taken us to the facts, is that he's got a fee for children, and the question is whether it's compatible with Section 50 to have such a fee.
Yes.
But our case is different.
Of course our case is different, but I don't think...
And this case doesn't apply to our case.
No. I don't think that the appellants, I'll be told if I'm wrong, would disagree with my proposition that the exercise set out in Little Roman 5 is a description of what Section 55 consideration requires.
It's a description of what Section 55 may require in a particular case, yes. It's not an exhaustive definition, is it?
Well, I can't think of circumstances where it wouldn't apply. Firstly, in identifying and considering the best interests of the child, or indeed children more generally, and then weighing those against other considerations when making your choice.
I mean, I'd say, except in a theoretical situation which one can't imagine, where there were no other considerations, every decision is basically multifactorial, and this is one of the factors which you have to treat as a primary consideration, but there will inevitably be others. They may point in the same direction.
Yes. It may be trite. The point I'm trying to make, I suppose, is that when you're considering a range of policy options, that is relatively clear-cut. That exercise. Identify what would be in the best interests of the children who are here and want to sponsor a parent or a sibling, then look at the other factors that outweigh it. How is that balance struck in respect of the policy option Secretary of State thinking of adopting? But in suggesting that the Secretary of State has to go through this exercise on a regular basis to review the immigration rules, it suddenly becomes a lot more difficult, doesn't it? So the immigration rules are vast. It's being suggested that the Secretary of State has to continually keep all of those rules under review and ask, in respect of each one, looking at the best interests of children and other countervailing considerations, which are likely to be the demands of all sorts of other rules, do I think that at the moment I should be reviewing that rule, or should I commission a policy review for this section of the rules? It's not that's quite not in my submission the exercise or discharge of a function for Section 55 purposes. It's a prior step. The Secretary of State has a very, very broad power stroke duty to decide which elements of policy, the rules, guidance he's going to consider at any particular time.
Yeah, so your point is the very rigour required to do a Section 55 exercise is inconsistent with the idea it's something you need to be doing all the time.
Exactly.
Yeah.
Yes. Or you end up in the situation that the Lord Justice Lewis put to, I can't remember if it was Mr Hussain or Mr Podger very early yesterday, was, well, can somebody trigger this just by writing to the Secretary of State and saying, I think you should be reconsidering this part of the immigration rules. You know, they cause very adverse consequences for children.
Yes.
Does it make a difference if it's a body of people? I mean, plainly there are strong feelings about this. You've seen that it's been raised in parliamentary debates. There is, in fact, another private member's bill, as you're probably aware, going through its House of Lords committee stage at the moment. But ultimately, the Secretary of State, who has got much wider interest to balance and very multifactorial what she is going to devote her attention to and those of her officials from time to time, must have a broad, very broad discretion to decide which rules and which policies to revise, presuming they are otherwise lawful.
Yes. I don't blame you at all for we're starting with this, but you are starting with the easiest bit. I'm not really sure that Mr Hussain was any more developing. If he was, it certainly wasn't the focus of his arguments. The sort of rolling review might be more relevant to Mr Pobjoy's submission. But and I'm sure you're going to come to this, but we've got to meet his case at its highest, or at its strongest, which is, as he says, its strongest, is particularly what happened in 2018. You're going to...
My Lord is once again a clear step ahead of me, but I was about
No,
to...
well, no, I shouldn't, it's annoying, but
No,
it's just,
no.
I will wait.
No. But just to make my last point on this, I think it's probably a point that was inherent in everything else I've said, but adopting any other approach is putting the cart before the horse. Without meaningful policy options, how can the Secretary of State conduct the balancing exercise that Section 55 requires? My last point on this.
Yeah.
So against that background, I'll turn to the potential targets. The targets that the appellant identified, Mr Hussain identified in his submissions, by which I mean the points at which he contends the Section 55 duty bit, a function was discharged or exercised. Now, the appellants address this in their skeleton at section paragraph 57 and 58. Would it be helpful to turn those up now?
Yeah.
rejecting a recommendation of the House of Lords European Union Committee and House of Commons Home Affairs Select Committee. He didn't pursue those, you'll recollect. So I'm not going to address them, and I hope they won't be gone back to in reply, because I'm sure Mr Hussain wouldn't. Then we get to 58. And that's a 2016 amendment to the policy. But I think after some discussion with my lords, Mr Hussain said, well, he wouldn't focus on that. That was a change to the policy. It wasn't a decision about the rules. His strong point was 2018. That's why my Lord Justice Underhill asks me to address a position in 2018. So, the Secretary of State is said to have reviewed her position on a family reunion. And that's apparent from the content of the ad hoc query of February 2018 and the Home Office's response to a 2018 report of the ICIBI, which asserted it was reviewing the approach to family reunion, including in light of 2 private members' bills. The rest of this is simply saying that the post-decision evidence, or post-hearing evidence, doesn't suggest that those statements were inaccurate. And will, in her Part 18 response, we'll be careful about this, the respondent section made a decision to this effect after July 2018. But can we start by looking at the evidence that underpins that? Supplementary bundle, page 247.
So sorry, I just didn't hear what.
Supplementary bundle,
Yep,
page 247.
yep.
That's the EMN report, you'll recall, February 2018.
Yep.
The UK are currently reviewing the policy on refugee family reunion, listening to the concerns from non-governmental organisations, but the current policy and immigration rules on family reunion are too narrow. This work is part of our wider asylum and resettlement strategy. We're gathering evidence on whether changes to policies creates a pull factor that may lead to more people risking dangerous journeys to Europe, and on the number of refugee family reunion applications that could be expected, with associated analysis of the impact of the cost on public services. This is not. We are currently considering whether or not child refugees should be allowed to sponsor their parents.
Well, hold on a moment. At the very least, you're asking for information about whether child refugees should be sponsoring their evidence. You're asking that question, aren't you?
We're asking for information that would be relevant to that question. That's definitely right. But this doesn't say ministers are considering doing that.
No, but she's currently discharging a function. She's obtaining information about topics of interest.
Yes, I'm not quite sure what my lord's putting to me. Are you saying that in gathering this information, she should be having regard to the best interest of children as a primary consideration?
I'm saying she's got to make arrangements for the discharge of functions. At the very least, we know that she started the process of acquiring information
I would.
about
Yes.
things to do with whether children criteria too narrow.
In a broad way,
In a broad
she
sense.
is definitely gathering
Doing that.
information
Yeah.
about a whole range of family reunion questions, including the position of child refugees.
I mean, can't it be said that we know more than that? We know that she is reviewing the policy, and reading on, we know that she is reviewing the policy specifically in relation to family reunion and pull factors.
Yes. That's wider than just children. And
But it certainly includes children, doesn't it?
it certainly includes children, yes. It'll become clearer when we look at the next document, I hope.
Can I just, sorry, my lords have gone straight to the key points. Can I ask a much more trivial point, but just confuses me? The third line of the introductory remarks, this work is part of our wider asylum resettlement strategy. We are gathering evidence on whether changes to policy creates, could presumably be create, but creates a pull factor.
Yes.
The natural thing to say would be we're gathering evidence on whether our current policy creates a pull factor, or does it mean changes to policy would create a pull factor?
I think
it must mean the latter, mustn't it?
It must mean the latter would create.
It must mean that it must. There may be other bits, but on the bit we're concerned, it must mean if we changed our policies so as to allow child refugees to sponsor their parents.
No, I wouldn't go as far as the last bit. I mean, I don't think it should be interpreted as if it was a statute.
No, but I of course, I agree with that. But I'm still a bit puzzled by why it refers to changes to policy.
Does it not mean we're asking all these other countries, have you changed policies in ways that have generated more people coming in?
Yes, yeah, that's a neat way of putting it, if I may say so. I think you could contrast it, for example, with the Belgian EMN request, which is just before this. It's the preceding document. It starts at page 235.
Hang on one second.
Actually starts at 234, but the background information at 235.
Sorry, I needed to catch up. Yep.
Are you at 235, my lord?
Not yet, but I'm about to go there. Yes.
Can I just ask you to read the passage under background information? You can also look at the questions.
Yes.
That was the Belgians concerned the previous year, which was much more specific and much more targeted. I think it may also in part answer my Lord of Justice Lewis's questions to UNHCR about other European countries. But that's only part of the picture, and I accept it's fragmentary. I went to it first because Mr Hussain relied upon it first. Things become clearer when we look at the Chief Inspector's report. It's actually the 2019 report, I think. Supplementary bundle still.
Tab.
Page 202. Tab 20. Oh no, that's the Home Office response. 19. So it starts at 209. Could I ask you first to turn to paragraph 5.36?
Sorry, I ought at my
82.
advanced stage to know what level a grade 6 is. What
Sure, I can be told from the
does this
highway.
have a title?
It's a senior lawyer.
Sorry?
Senior lawyer.
Ah, this is
Senior lawyer, thank you.
legal department. Civil servant in the home.
Am I right in thinking they've reversed it? It used to be 1 working downwards, permanent
Yes.
secretary 1, and now it works the other way. I don't know
I-
how that
Yes, I know it used
translates.
to be 1 working downwards. I didn't know it
Yeah,
had been
it's-
reversed. Anyway,
6.
But at the relevant time, which is not all that long
And
ago.
at the relevant time, it hadn't yet been reversed, so 1
Ah.
was still at the top.
yes, I think that's probably right. So 6 would have been.
Quite
We'll
junior.
find out for you at lunchtime.
I think we ought. I think
My
it's all-
recollection is that grade 6 used to be SLA in the old terminology years ago. Senior legal assistant.
Right.
What are we reading this for?
Sorry.
What are we reading this for?
We're reading it to see what is, because Mr Hussain relies upon, for the purposes of a review having been conducted in 2018, he relies on the introduction to the request that we've just looked at and the Independent Chief Inspector of Borders report, which also refers to a review. You've got to look at the sort of review that and this is more illuminating than the
This is
request.
his other part of 58 then.
Sorry?
This is his other part of his paragraph 58.
Yes.
Okay.
And I'm just trying to read the whole of 5 under the 2019 heading.
Yeah. Page 209 of the supplementary bundle.
Yeah. So one of them said they aim to review family reunion policy every 12 months. But because they've got private members' bills and they don't know the outcome of that, all they've done at the moment is redesign the online form.
But it's pretty clear that we're looking at family reunion more widely. Okay, you see more specific to child refugees if you turn on to page 215.
Hang on 1 second.
The thing is, Lord Justice Singh has just given the judgment saying we shouldn't be trawling through reports like this. Somebody should make a proper witness statement explaining what happened. It is surprising that there is no witness statement from any government official telling us what actually happened. That we're trying to get it, not from a Home Office source, but from reports describing a Home Office source. Anyway,
Well, not anyway. Something I was going to ask myself. Now's as good a time as any. It's odd in this case, not only on this issue, but let's vote. There's no evidence, frankly, at all. There's some small counter evidence from Mr. Bulchins, which of a very general nature, on a point raised, but there's no evidence supporting the Secretary of State's case at all. I've seen this in 1 or 2 other cases recently.
Yeah.
Why not?
Well,
Or why not in this case, anyway?
Why not in this case? Probably because of the way the case has evolved over the course of the proceedings. You have seen that there are 2 judgments. There were questions to counsel after the first judgment. The claim has been amended and re-amended. I've taken you to the way it was initially put, which was in establishing and maintaining. The focus on, my Lord Justice Lewis asked the appellant to identify the specific dates and decisions that they were focusing on, if you'll remember.
oh, yeah, I do remember it because I was trying to work out what had happened.
Yes. And so, in fairness to the Secretary of State and the team, myself and the team behind me, it's not always been clear that there was a focus on a specific decision. It was really in response to my Lord Justice Underhill yesterday that the focus came clearly on 2018. But what there has been is witness evidence that is consistent with this, which is that it may help, I don't know which to go to first, whether to look at the 2 paragraphs from 215 or to look at the witness evidence. If we look at the witness evidence that we looked at from Miss Elimelech at pages 326 to 328.
Did they have permission? It wasn't a roll-up hearing, was it? They had permission for the Lavender J case.
Yes.
So you knew something was hurtling towards you. You're...
I mean, perhaps this won't ultimately, we've got to manage with what we've got, but in case we want to say anything about this, it's quite apart from your point about the evolution of the particular arguments, the nature of the case changed substantially at quite an early stage when leave to enter was granted to the family. I can't remember how long after. That was after the issue of proceedings.
Yes.
And Secretary of State, for I'm sure good reasons, was willing, I think possibly encouraged, but certainly didn't oppose this continuing on what might otherwise be said to have been an academic basis, certainly academic basis as regards this claimant. Maybe that sufficient review wasn't really done at that stage to work out, given that this was now a case entirely about the Secretary of State's broad policy, whether a different evidential approach would be appropriate. You needn't answer any of this. You just need to know what's going, at any rate at this stage, you need to know what's going through our heads if we choose to say anything about this.
Probably the best response I can give immediately is to say I haven't gone back to check when 2018 was specifically alighted on as being a point at which we've already seen it's at multiple occasions is how it's been put before this court, including the following responses to select committees, 2016, 2018. That's addressed in the statement. So it's always been put very broadly. Okay, the Secretary of State has made decisions not to amend at various times. She's maintained her position of not amending. Ms. Elimelech deals with it in a similarly compendious sort of fashion at page 328, at paragraph 12.
Well, let's leave this for the moment. I think we are where we are. If the Secretary of State has not produced evidence that she needs to produce, that's her problem. But you say, or even if it may be suboptimal, we have A, there are reasons, and B, we do have documents from which inferences can properly be drawn.
Well, I also say you have got witness evidence that addresses the point of whether ministers ever conducted this sort of a decision.
No, it doesn't. It says they've been consistently clear that they do not wish to amend their policy position. Doesn't tell us why they were asking those questions of other countries. Doesn't tell us whether the Home Office minister said, well, I've heard all of that. I thought about the children here. I'm worried about the children abroad. I'm sticking with the line. It's very carefully worded. It doesn't go through what the Home Office were doing, why they were looking for experience from other countries. They must have been doing it for a purpose. And it doesn't tell us.
Well, I was trying to take you to the Chief Inspector's report to sort of demonstrate reviewing family reunion is an ongoing practice. They are always gathering information, which would include the information gathered from the EMN in an information request. It is an ongoing exercise, and quite properly so, one would expect it to be. That's why I started off really with addressing the court on what is the discharge of a function, because my case quite simply put is, yes, there are ongoing generalised reviews. There has never been a point where the Secretary of State has commissioned options and said, okay, I'd like to look at the possibility of maintaining the status quo or alternatively introducing some criteria. I would like officials to draw up for me some alternative criteria, an alternative set of criteria, or two, or three.
And if that had happened, what we would have seen is what we often see in cases, basically some paper to ministers, with, if it's appropriate, the minister's response to that paper. And you say there isn't any such paper, and there is evidence, there is effectively. One thing Dr. Elimelech's evidence does show is that there is no such paper, because that is the sort of paper that would have been produced on the search that she's done.
Yes.
And you're making a fundamental distinction between that kind of exercise, which would be well understood by civil servants, and this kind of exercise, which you characterise as ongoing generalised review, different from commissioning options for a ministerial decision, or different from minister commissioning options for a decision by him or her.
Yes. That's precisely how it's our case.
And is that might need some refinement. We of course don't have any real evidence about civil service procedure except what we all pick up in a long life. But you say that one could argue about exactly where you draw the line, but broadly speaking, that's a fairly clear-cut line.
Yes.
Yes, I see.
If my instructions had been, our defence to these judicial review proceedings is the Secretary of State discharged Section 55 in 2016 or in 2019 when she commissioned a review, considered the policy options, took into account the best interests of children, and here is the relevant evidence.
Yeah.
It wasn't. Our case has always been that it hasn't been done. It's not the Section 55 exercise.
In a way, it would be a lot. It would be much better for you if it had been done.
Definitely. Yes. Well. At any rate, clear.
No, it would be a much more straightforward
decision.
case because
Yes.
I'm just not. It didn't happen, so we don't know. But what one would expect is, if there had been some sort of formal review by that, it is in the real world certain that there will be some reference to Section 55 in the paper that went to the minister.
Yes.
There might then be arguments that it wasn't adequate or it didn't do a proper
Yes.
exercise.
Yeah.
But the idea that in that kind of exercise ministers would not have had their noses rubbed in Section 55 is absurd.
Yes, indeed. So our defence to these proceedings would have been very different. It would have been, here's the decision, and it complies. Or alternatively, we accept it doesn't comply and we'll redo it. But that's not our position. Our position is Section 55, in terms of amending rules, was never engaged because ministers didn't want to go there.
The problem that I've got is, or another problem that I've got is this. Sounds as if the evidence has gone along this line. We've decided what Section 55 means. It means commissioning policy options. We haven't done that. That's our evidence. But the evidence is what they did and what they might have done. And we might take a view that must make arrangements for the discharge of functions means that if they're going to acquire information and start considering whether or not things are appropriate or whether things need to be changed, that they must build into that process Section 55. And you haven't got any evidence at all about what you did less. And you've just got to live with that, I think, haven't you?
Well, you're worse than that. I think it's clear that for these purposes, you're not saying you did consider Section 55. So you've got to win on this point. You've got to say this is not what happened in 2018 is not the discharge of a function.
Yes.
Yes.
That's always been our case.
You're happy with that because you think you can win on it.
Yes.
But if you do lose on that, there's no evidence, probably it didn't happen, but there's certainly no evidence that the review that took place in 2018 did have regard to Section 55. And you're also saying, more generally, that the minister's repeated attitude, let's call it that they didn't want a review because they wanted to stick with the policies it was, is not itself the discharge of a function.
Why would they ask for information at all? It's a waste of time and money.
Well,
Here and abroad.
I can only speculate that there were private members' bills going through at the time. The Home Office would want to be kept informed. It would want to have background information.
Yeah, that's not the flavour. The flavour of this is that, in a sense, that the private members' bills are a complication or an obstacle.
Well,
it's not being done for the private members' bills, is it?
well,
That's what I'm just reading the flavour of 536.
Yes.
You were going to take us to page 235, wasn't it, weren't you?
I was.
Or to another page.
I
Anyway.
referred to private members' bills because that's what they refer to at paragraph 5.36.
What was the other page you were going to take us to?
The other page I was going to take you to was 215.
215. Sorry.
paragraph 6.15.
Yes.
And
What
then-
what submission do you make about 616?
Well, as one would expect, decisions to change the rules aren't made by civil servants. They're made by ministers, and ministers have made clear that they did not want to change this aspect of the rules.
Not just decisions to change the rules, decisions to review the rules.
Well, with a view to changing them, yes, to consider amending.
That's quite surprising and may have problems. You rather expect governments to be considering things. That's partly why they're there.
Well, there are a lot of things for them to consider, and this was something ministers were very clear they did not want to consider at that point.
Can I just talk around it a moment? Section 55 doesn't only bite on things done by ministers personally. We see from paragraph 5.36 that a civil servant explained that there was an aim to review family reunion policy every 12 months. Just take it for a moment. Suppose that such reviews had regularly included looking at the position of whether child refugees had been able to bring their parents. Would that have brought in section 55?
Depends what the review was. Keeping something under review is different to discharging a function, I think, or making a decision. We know from the cases that making decisions in individual cases is a function for the purpose of section 55, and that making or amending rules is a function for the purpose of section 55. It's not to say that officials don't have regard to the best interests of children in a general way when they're doing that. It's not section 55 sort of evidenced function in that same respect. It's not a
supposing that the department sets up a system, which presumably it did, under which an official was charged with reviewing family reunion policy every 12 months, and supposing further, for the sake of argument, that that encompassed looking at whether child refugees should be able to bring in their parents, still section 55 wouldn't bite.
Well, then they wouldn't be making a decision for the purposes of section 55, my respectful submission. No, I mean, one would expect them.
So it depends. What the key point is that you're saying that the review exercise would not involve making decisions.
Yes. It wouldn't be making a decision for the purposes of section 55.
Well, section 55 doesn't use the language of decisions.
I mean, suppose the official was deciding whether or not to make a recommendation to the minister, which I dare say is commonly what happens. He's making a decision, he's deciding whether or not to make a recommendation to the minister. Does section 55 apply?
Can I just reflect on that?
Yes. You can reflect till after lunch if you like. It's quite an important question.
Yes, it is. I will reflect until after lunch. There's a very recent decision of the Supreme Court in, I think it's called CAO, it's a decision in Northern Ireland, I don't know if any members of the court have seen it, about whether there has to be specific reference to the guidance when you're making a decision that engages section 55. The key issue in it was whether section 55 bites on the tribunal as well as Secretary of State and decision makers. And to find, I'm not answering the question, but it would certainly be a very very substantial widening of the Section 55 case law to date to say that it applies not just when decisions are made in individual cases.
Well, you will look at that decision and see whether it would help us to look at it. We might want to look at it anyway, just for our background. Is it called CAO?
Yes.
But
so the fact there isn't a Section 55 statement wouldn't be determinative of it. Now, I was going to deal with this really under Mr. Hobjoy's continuing duty. I think it falls in within that generally.
Yes, I see.
Because you wouldn't expect an evidenced decision, the way you get an equality impact assessment, for example, saying we've taken into account A, B and C, and this is the decision we've come to. We've weighed the best interests of children, again, because that's a matter for the ultimate decision. But I certainly accept that, for example, in conducting their ordinary functions when a child, an unaccompanied child, arrives in the United Kingdom, in the way the child is treated, given first aid, arrangements are made for their accommodation, all of those functions will have regard to the child's best interests. It's a slightly different exercise to the exercise that was being considered in the registration of British citizens case. But all of the Secretary of State's guidance is saying to officials, in everything you do, that you must have regard to Section 55.
The Act is the legislation. It's what Parliament has said ministers must do. And Parliament has said ministers must make arrangements for the discharge of any function.
Yes.
Because Parliament presumably thinks it's very important that we look at the welfare of the interests of children.
Yes.
So how can the Secretary of State say, I am not going to look at this? How can she also say, my officials may look at this, but unless when they're carrying out their day-to-day duties of looking at things, they're not supposed to, Section 55 doesn't apply to them.
No,
so they can't come to a situation where they say, really, Secretary of State, the time has come, or the time hasn't come, to look at this. The evidence is mounting, things have got worse. Parliament wants you to make arrangements to make sure that when you go about your business, in other ways, discharging functions, you do so having regard to the interests of children in the United Kingdom.
Yeah. I've been trying to reflect, because I didn't want to give an incomplete or misleading answer. I hope I have largely answered it, that Section 55 has to inform the best interests of children have to be taken into account in all of the functions of officials.
And you can change discharge of functions to going about your business.
Yes.
And the business of government is to govern. Clues in the title.
Well,
but the focus of this judicial review challenge is not on that, it's on making a decision whether or not to amend the rules.
Yeah,
and that is a matter for ministers.
It's yes. It's really quite a self-contained, if you like, exception to the application of Section 55. I think analytically you say it wasn't an exception, it was something on which Section 55 doesn't bite in the first place. But call this an exception as a shorthand. It's quite a self-contained section, because what it's concerned with is not matters which would normally happen in the Department without reference to the ministers. It's about, I'm really repeating what you put, I'm just trying to internalise it, it's about whether to change the rules, which necessarily is a ministerial decision.
Yes. So the answer is yes, Section 55 would bite, would be engaged, but that's not the decision that's under challenge. The decision under challenge is the decision is, well, the asserted decision not to change the rules, and I've already explained what that would involve on the part of ministers. It's a decision for ministers, and it's not one they've taken.
And you're saying that this, whatever these reviews were, which is slightly unsatisfactory, we don't know what they are, there's nothing to suggest, you're saying, that, or to show that they are reviews aimed at getting the Secretary of State to change the rules. Civil servants have not been asked to put up a paper,
Exactly.
and it's not for that purpose. It's not really for them to generate that process. Civil servants don't put up papers to me because they think it would be a good idea.
No.
They do what the minister asks them to do.
Yes.
Who decided to send a letter
Well,
to the European countries asking for the information? Was that a ministerial decision or was that a civil servant?
Well, I asked about that because you raised it. I was told it would be very unusual for it to be a minister. It's generally a civil servant, but they haven't found the background papers to that particular request.
It'd be quite surprising if that were a grade 6 decision.
However, senior grade 6 was at the time, and we will try and clarify that.
we know.
I'll try and get some more information from you. I think there was a person who was the point of contact who had the responsibility for doing it, but they would be tasked.
Well, it was we know it was the national contact. The request was by the national contact point,
Yes.
but we don't know who that was, what senior.
Yeah.
But you're saying on instructions, which itself is not terribly satisfactory, but that on instructions, this isn't the kind of thing that a minister would be asked to authorise.
No, it would have been authorised from within the Home Office,
Yes, but
but it would be unusual, although the emails that can't be 100% certain on this occasion, but it wouldn't generally be done by a minister.
and just looking again at the language. It does start, UK are currently reviewing the policy, but it really plugs back into the same arguments. Okay, I think there's limited time. We've done this to death, subject to any further material which we allow you to put before us.
May I just ask about 367, the request for further better particulars than the answer?
Well, I think you're coming to that next.
Are you coming to that next, do you?
Yes, could I
Oh,
just go to
right.
one more bit of the ICIBI report, and that's 6.17 at the bottom of page 215.
Sorry, which page?
At the same page we're at, 215, paragraph 6.17.
Yeah, all right.
Trouble is, it's quite cryptic what that means.
There was a public consultation in 2021. I mean, it did not include the question of whether children in the UK should be allowed to sponsor family members. I've been sort of trying to draw out that the question of family reunion is wider than simply the question of child sponsors. There was ongoing work, and I think that there often is. You will have teams in the Home Office who work on particular areas.
Okay.
But the short point is, ministers did not commission a piece of work to put up
Well,
options for change.
We have your point now. What do you say about the request for further betting?
Yeah, the RFI, the request is at 365. It essentially, at 4.2, repeats the way the case was put in the appellant's skeleton argument, refers to the ad hoc query and the response to the 2018 report of the ICIBI, asserted it was reviewing the approach to family reunion in the light of 2 private members' bills.
Yeah, but this is their drafting, so
This is their draft.
and it's the context. So we actually want to know what the actual request was.
And by necessary inference, the respondent made a decision either before, during, or following the review. And then the request was, what's the date of that decision?
Yeah.
And that's 367.
And the answer is at 370
Yes.
after July 2018.
But that
In the light of your submissions, that is a wrong answer. The answer should be, if consistent with your submissions, the respondent, that is the Secretary of State, made no decision.
Yes. Say that I'm in context, it's pretty clear to me that officials were interpreting this as, when did the Secretary of State say again she was not proposing to change or review or consider her position in respect of creating an immigration rule for child sponsors?
But even if that's the case, she should have said she's done so consistently, including after July 2018.
Yes. Well, yes. I don't think very much can be derived from this. That is not intended to communicate that there was a ministerial decision of the sort I have described.
Despite the fact that explicitly the request, admittedly in the context, but fair enough, says by necessary inference the respondent, as the Secretary of State, made a decision to this effect. That she was not prepared to change the status quo.
Well, you've seen the evidence that ministers were continually telling officials they were not prepared to change the status quo. I mean, it's described as a ministerial red line, but it was Ms. Elimelech and Mr. Bulchan say the same thing. Ministers' consistent instructions to officials were, whereas it's after 2018, because
Well, can I just check the chronology of this, actually? We've not had a witness statement from the Home Office. We had the first judgment and they had applied for permission. And in the order, I can't remember what date I made the order, I was clearly troubled by this. And in the box that says information to the parties, I did say, would you please identify the decision and the date? So it was pretty clear the court was actually asking somebody to help. And you have helped. You've said the decision was taken after July 2018. In the context of what the court was asking for, there can't have been any doubt. I wasn't asking, has she got a material red line? It's clear what the court was asking.
I don't immediately have to hand what the court was asking.
It's in the order that granted permission. It'll be in the core bundle. Because I think this, Mr. Hussain will tell us, but I think this was a response to the order from the court, wasn't it? Because you didn't have the dates. So you've got to look at the order at page 91 to 92, which, oh no, that's the earlier one, and the later one. So where's the order granted permission?
Well, it is at 91 to 92.
Oh, yes, 91 to 92, yep. And then I say information or directed to the party, as well as dealing with what is described as the generic issue. In order to enable the court to deal with the appeal, the appellant should identify precisely each act and the date of each act said to amount to an exercise of function. I was trying to be as clear as I possibly could, and that's what you come back with.
And that's partly because my lord was obviously concerned about the time point, which is no longer alive. And not saying only for
It
that
wasn't
reason.
only that, but yeah. But so you know what the question is about. So when you come back saying there was a decision after July 2018, some people might read that and be thinking there was a decision.
I'm so sorry, I'm at 91 and 92.
Do you see at the bottom, information for or direction to the parties?
Oh, my page numbers are not the same as yours. I'm so
No,
sorry.
it's
that's
the order
fine.
granted permission to see on the 24th of September 2024.
The appellant should identify precisely each act. And with
Yes. But then they said, as I understand it, I've got this wrong, we can't do that because the Secretary of State hasn't told us. So they wrote to you with an RFI
Yes.
and said, tell us so we can answer the judge's question. That's the genesis of all this.
Yes.
Paragraph 2 of our
Yes. Yeah. But the RFI was, well, you see what the RFI asks. It asks about the review that was referred to in the EMN and to the independent chief inspector. And that review was not a review by the Secretary of State personally. It wasn't a decision by ministers. It was an ongoing review by officials, as described in the Independent Chief Inspector's report. I'm so sorry that I'm not able to help any more,
No,
but that
no.
is it.
You know, there's a limit to what you can say. The text says what it says, but we don't want to play this entirely on. Right, where are we going next?
I was just going to take you to the judgment in the full bundle.
Yep.
Paragraph 140.
Yep.
The judge below was prepared to accept the evidence of Mr Bolton's to the effect that the Secretary of State and Home Office ministers have not given active consideration since 2nd of November 2009.
Of course, he didn't have the request for information, did he, by definition?
Well,
He can't have because it came after.
yes.
The other trouble is that what Mr. Butchins is confirming, which is by reference to the submissions, is potentially very narrowly worded. If you look at tab 30 in the supplemental bundle where you find the submissions, page 320.
Hang on 1 second, sorry.
And 320.
Yes.
I mean, it does say in paragraph 10 that records indicate the consistent position of decision makers. The particular paragraph, paragraph 9, the Secretary of State is not aware of any occasion when the relevant decision makers decided to review in order to consider providing a route. So is that limited to deciding to consider providing a route?
To consider providing a route. Well, that's what's being asked for. Really,
Yes, I see.
think.
So that is in fact, well, it says it's carefully worded, but I said we can't object to that. It's consistent with how you were putting it.
Yes. And then it is carefully worded because you'll see it at paragraph 11. We're dealing with matters some time back. But they did conduct a search and weren't able to find relevant communications from ministers to officials back beyond 2015. But they do have records from 2015 onwards.
Yes, and that's where now the
We're
focus has
focused.
really
Yes.
settled down.
And they indicate the consistent position of the relevant decision makers as communicated to officials has been they are not prepared to change the existing and long-standing policy. And then the rest of that paragraph includes a reference to the 2021 consultation that I referred to. And the policy was not one of the options to be included in the 2021 consultation. Now, you may disagree with that, you may have concerns about that, and I'm not trying to sort of persuade you on the merits that that was an excellent approach. But in terms of this particular challenge, which is to a reported decision, in my respectful submission, the response to the RFI is not as clear and unambiguous as it should have been, but it's rather, I'm not using my law taking pleading points, that's to be measured against this clear and unequivocal evidence that they have search records and there has not been a decision.
Of the type that you described.
Of the type defined, which is what we said, which is why I started off by saying what is the decision at issue in these proceedings.
Right. Well, we see your position on that. We may have had some trails on. We haven't had your decision, your submissions on Popjoy yet.
No, you haven't.
Sorry, Mr. Popjoy.
I'm sure he won't take offence at that. Can I possibly just get a little more water before I...
Yeah, you can have mine actually, unless somebody objects to me giving you water.
That's very kind indeed, my lord.
There we are.
Thank you.
So I was going to move on at that point to the second limb, which is the operating system border function. And is the public sector equality duty a continuing obligation? And in my respectful submission, yes, it can be.
So you deliberately mean the public sector?
Sorry, I mean section 55 by
Yes.
analogy with the public sector equality duty, because that's where most of the case law is. And I was going to, rather than deal seriatim with the authorities that from the 6 cases that he relied upon, take you, I'm afraid, to one more, but it's quite modest. I hope it's been handed up. It's the Metropolitan Housing Trust and TM case.
I don't think it has been handed up yet.
Mr Anderson has it.
Thank you very much indeed. A tiny case management point, always useful if you're going to, while you're sitting now twiddling your thumbs waiting for us to arrive at 10 o'clock or 10:30, get these handed up,
I'm so sorry.
then they're there. Yeah, okay.
So this is a decision that was concerned with the public sector equality duty. You'll see from, it's a decision of this court, relatively recent, December 2021, and it concerned possession proceedings that were being taken against a person who had mental disabilities. And you'll see the facts set out very briefly in the background at 1 to 5. And I wonder if I could pick it up at paragraph 25, bottom of page 7. So the landlord of Metropolitan, it wasn't disputed that the public sector equality duty applied to Metropolitan. The relevant decision maker was Mr Print. On 26, you'll see that he took a number of steps. And at 2, that included trying to get some advice from Dr Koch as to capacity. Then he issued the notice seeking possession on the 1st of June 2018, and the possession proceedings went ahead. Then at 27, you'll see that although he didn't have a report from Dr Koch when he carried out the assessment required by the PSCD, Dr Koch did subsequently provide a report in October 2018. And that report essentially said that TM wasn't fit to instruct a solicitor, lacked capacity, experienced significant symptoms of schizophrenia, and that taking part in the proceedings would adversely impact on his mental health. They had that report by the time of the first hearing on the 29th of October. And one of the criticisms was that the duty was a continuing one and that Mr Prince should have reassessed the position when he got the report. 36, no dispute that there was a breach of the PSED in not reassessing, and that breach continued at least up until trial. And this is, in our submission, a very good example of where you have a continuing duty. You can't look at this in terms of a decision to take possession proceedings. There is a continuing course of conduct leading up to the trial and the hearing, and in those circumstances, the duty is continuing. And I suppose by analogy, in the immigration context, is the example I gave of a child who arrives on the south coast, and there will be a number of immigration functions that are conducted in respect to that child, all of the people interacting with them on behalf of the, or her, on behalf of
Sorry,
the
can you speak up a little?
Oh, I'm so sorry.
I'm getting deaf.
All of the officials interacting with that child and exercising functions, which may be the fingerprinting or maybe providing them with food or trying to sort out accommodation, all of them in Section 55 contracts have to have regard to the best interests of the child in doing that. What we're concerned with here is not a continuing function of that sort that gives rise to a continuing obligation. Nor is this the operation of a system. Like, for example, in bridges, where, oh, sorry, it's 1 o'clock. Do you want me to pause there, or should I finish this sentence?
Well, by all means, stop at a convenient moment, but...
I was going to say bridges was another example, because it was an ongoing trial of automatic facial recognition.
Did they not say something about it doesn't matter that it was a trial or something?
It didn't matter that it was a trial, as opposed to having introduced AFR. You see what I mean?
The problem is, Section 55 bites on a number of disparate things.
Yes.
One is a situation where you're just dealing with an individual and his set of facts. It's certainly continuing. His facts may change.
Yes.
Sadly, the parents could suddenly die in the middle of the process, so things can change. But when you're dealing with other functions, the functions of deciding who should and shouldn't get immigration,
Yes.
that isn't continuing in the sense of one process. It's obviously you make the rules and they are the rules until you make some new rules. But inherent in the whole process of a system of having rules, it could be said, is that you've got to consider from time to time whether the rules continue to be fit for purpose. If we left the Refugee Convention, you'd have to consider whether the rules now were appropriate because you've granted refugee posts. We had to change them, presumably when we left the European Union.
Yes, but that's a really, really wide power that the Secretary of State exercises, and she is not under an obligation to change specific rules at specific times.
No, but he is under an obligation to make arrangements to ensure that the discharge of functions, which must, it is said, include the keeping in place rules that are appropriate to circumstances. The making arrangements for the discharge, it is said, quite simply, involves a need to consider and build in a requirement for review of reasonable intervals. And what's reasonable may be a question of rationality and may depend on the circumstances. But it's all to do with the words of Section 55. Anyway.
It is a good moment.
Just before you do, I mean, it might be said that's what the Secretary of State did do, because we could see from the report that one or more officials were charged with carrying out reviews every year.
Yes. What didn't happen was that the Secretary of State at some point commissioned the sort of process that I was referring to, as in Badmus, for example, where she said, I would now like to consider introducing a rule along those lines. I'd like somebody to set out for me the various policy options.
Right. I think I would certainly be grateful if one of your team would get to the bottom of your submission about when the focus really on the 2018 review emerges and how that's relevant to the decision, what evidence to call or to adduce. I can't think of anything else we asked you to do over lunch. How are you doing for time?
Quite well, I think. I've got not very much more to say.
And this is in a way the most complicated part. Very well. Well, in that case, I will say 2:05.
Thank you very much.
All rise.